column. Lordship has substantially heard this matter. This is an ONGC tender matter, Lordship.
50.
Supplementary 58, 58, 960 in the supplementary list.
Okay.
So what I am praying, Lordship, if it is not inconvenient, could it be taken up, Lordship, around 12 o'clock?
Oh.
I have already taken the consent of the other side senior counsel, Mili Hajurika also. Okay. It will hardly take 10-15 minutes. Lord.
I heard this matter.
Yes, Lordship. This was a matter before Lordship went to outstation bench. Then Lordship was heard it the whole matter. Then only one record we have to produce on behalf of ONGC. That record, along with the affidavit, we have already filed. So we have to just place it the affidavit today. Highly obliged.
May please, Lord.
Yeah.
I beg to mention an item number 19, Lord.
Yes.
Sir, in this case, Lordship, respondent number 3 and 4 has filed on the affidavit, Lordship. I have to file my reply. So I may be given 4 weeks time, Lordship.
Okay, on request made by B. Sharma, learned counsel for the petitioner.
19.
Mr. B. Sharma, learned counsel for the petitioner, appraised for 4 weeks time to file reply to the counter filed by the respondents 3 and 4.
3 and 4. Well, I am appearing for 3 and 4.
Okay. Appraised allowed list after 4 weeks.
My presence may be requested.
Okay, Mr. B. Gogoi, learned. You're the standing counsel or?
Well, it's for the municipal board matter. 3 and 4.
Learned counsel, appraised for the respond number 3 and 4. Okay.
Lordship, I beg to mention item number 39, Lordship. Lordship, the order has been
Item
39.
39.
The order has been complied, Lordship.
Okay, Mr. N. Gogoi.
And the Gogoi.
I pay for the respondents in
For
the
respondent.
case.
Okay, Mr. N.J. Gogoi, learned counsel for the petitioner suppose that the respondents have complied with directions passed by this court. Stop. Mr. B. Gogoi, learned counsel, appears for the respondent.
Respondent number 2.
For the respondent. Contempt petition is accordingly closed.
Obliged,
So I may be allowed to call an affidavit file in item number 31.
Item
31, Lordship. I filed an affidavit, Lordship, already.
this morning.
No, Lordship. Yes, yesterday already I filed.
Okay.
Please, Lordship. Lordship, I beg to mention listing of an item, Lordship. The matter was last listed on 10/1/2025.
Okay.
Lordship, the matter may be fixed on 26th of this month,
2nd April.
2nd April. Obliged.
Item number 29, my lord. I pay for the PWD. My instructions are awaited, my lord. Can it be on 22nd of April, my lord? I've taken the consent of the other side.
Who is for the other side?
My lord.
Okay. But
29.
I'm not learned senior counsel for the petition. On request made by Mr.
April.
B. Gogoi, learned standing counsel B. Deputy. List the matter on
22nd of April, my lord.
22nd. 22nd April. To enable him to receive.
May I please your lordship? Lordship, I beg to mention for listing a case matter on Friday, my lord.
This Friday.
It's my
Why?
notice has been issued to me, my lord, for stopping of a stone cursor project, my lord. So, my lord, little bit of urgent. So, kindly matter may be taken on Friday, my lord.
Okay.
Highly obliged, my lord.
May it please, your lordship. Lordship, I beg to mention item number 37 of this daily list, lordship. Lordship, I have taken the consent of the other side. In this matter, my lord, we have to file our affidavit, my lord. Today I've sent it, I've sent it for signing. We're going to receive it, my lord, by today, by or tomorrow, my lord. We'll be filing it today or tomorrow, my lord. So therefore, my lord, we'll fix it on the next week, preferably on Thursday, my lord. Item number 37, my lord.
37. Who's for the petitioner?
I'm for the petition.
Okay, heard Mr.
My lord, A. Fukan.
I'm KJ Cycle.
KJ Cycle and counsel for the petition. Mr. A. Fukan, understanding counsel.
My lord, General Administration Department.
GAT submits and that the affidavit has been sent for vetting. And the same will be filed within a short period of time. Stop. Accordingly, release the matter on when? 27th?
Thursday, my
Yes, your
lord.
lord.
Next
27th March.
Deeply.
Deeply blessed.
Yeah, please, sure. With the consent of the other side, I beg to mention item number 18, Lordship. Fix up to 4 weeks, Lordship.
You're for the petitioner?
For the petition, Lordship.
Okay, on request made by Mr.
A. Bhattacharjee.
A Bhattacharya, learned counsel for the petition. List of the 4 weeks.
May I please, Lordship? So, Baker mentioned listing a petition, Lordship, next week, Lordship.
4th April, 4th April.
May I please, Your Lordship, kindly mention for listing, my lord, started file, my lord.
Hmm?
Kindly 27, my lord.
What did you file?
Listing, for listing, my lord. Started filing.
Fresh matter.
Yes, my lord.
What is the urgency?
My lord, contempt petition, my lord.
Contempt petition will come out
27, my lord, kindly.
26.
My pleasure, Lordship. Lordship, I beg to, I am begging for a listing of a fresh writ petition, Lordship. We are filing it today, Lordship. We have filed it today, Lordship. Lordship, we are praying for a date on 21st, Lordship, this month.
Why? What is the
Lordship,
urgency?
the urgency is that the respondent authorities, they are going to issue a NIT, Lordship. So, Lordship, similar matters were also pending before other courts, Lordship.
Oh.
And the division bench judgment is also there, whereby the whole process has been stayed, Lordship. So there is a similar matter, but the district is different, Lordship. So that's why we are praying for a date on 21st, Lordship.
Okay.
Very blessed.
May I please, Lordship?
Oh.
Lordship, I beg to mention for listing of a writ petition matter. Matter was, notice was issued, tender matter, and respondent have filed an affidavit, Lordship, and amount is admitted. Lordship, may I give the date for next week, Lordship?
Okay. 25th.
Marvelous, Lordship.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
Lordship, I beg to mention for listing of the Lordship matters, Lordship, I fixed it matter for Friday, Lordship, agricultural seeds out of the same tender matter, Lordship. Lordship has fixed it on Friday, non-payment of contractual bill regarding the agricultural seeds, Your Lordship. Lordship has fixed this eight matters on Friday, Lordship, out of the same tender, same matter, Lordship. On, if Your Lordship permits on Friday, Lordship.
You are filing a fresh one or it's only
Yes, yes,
filed?
Lordship, filing fresh only.
A fresh one that they'll have to see, consider the matter.
Yes, Lordship. In that
We'll
case,
have it on Monday.
Lordship.
May I please, Your Lordship, I beg to mention item number 6, Your Lordship.
Yeah.
Your Lordship may kindly adjourn the matter for the day, Your Lordship.
Yeah, for the,
And for the petitioner, Your Lordship,
you are putting on behalf of
DK Sen. Your Lordship, it may be taken up on 26th of March, Your Lordship.
on request made on behalf of Mr. PKC, non-counsel for the petition. Please, on. 2nd April.
Much obliged. Might be please, Your Lordship. Lordship, I beg to mention for listing one WPC matter. Lordship, may be listed on next week. In this matter, I am for the petitioner. As per the last order, I am file an affidavit in reply. Lordship, it's a railway matter. Its urgency is it's matter regarding permanent closure of the unmanned level crossing gate. Lordship, matter may be listed on next week, any date, 25th.
6.
Obliged, Your Lordship.
Lordship, I want to mention regarding listing of the contempt petition. Next week, any date on Friday,
April. What April?
last week of March, Lordship, last Friday, 28th.
28th is not possible. So we'll have it on 4th.
Okay, Lordship. Bless you.
Item 1 of daily list, motion.
Yes, please. I paying for Mr. A. Dekamil. Is regarding non-payment of bills of the vehicle requisition by the Assam police. So, notice may go, madam.
Yes.
Notice.
But Mr.
Yes, Botagon.
Yes, but of course, the counsel for the petition. By this writ petition, the petition is praying for release of outstanding dues amounting to rupees 20,65,699, correct?
Yes.
Stop. Issue notice.
All right.
Mr. M. Chitiel, the government advocate,
All right.
enters appearance on behalf of all the respondents. Stop. Extra copies. Respondents may file. Please stop the 4 weeks.
Two. May I please, sir? This matter relating to non-payment of bills, Lordship, for the supplying of materials, Lordship.
Yes.
Let I appear on behalf of respondent number 2, my lord.
2. Election Commission.
State Election Commission.
Hmm.
My lord, if your lordship would see, the claim arises out of lord, expenses incurred during the Lok Sabha elections. That is not within the domain of the State Election Commission. We are only for Panchayat, Municipal and Autonomous Council. But here, my lord, the necessary party would be Election Commission of India. Because it is within the domain of the Election Commission of India.
So you are not involved here.
No, my lord.
You are not the necessary party.
No, because State Election Commission has no role in the Legislative Assembly and my lord, parliamentary elections.
Then
Lordship, yeah, the work order was issued by the Lordship,
where's the work order?
yes, Lordship, Annexure 1 series, Lordship, starting from Lordship, page number 13. This issued by election officer Baska Musolpur, Lordship, Baska district, Lordship.
So that's the election officer.
Yes, Lordship, this is a party, Lordship.
My lord will see in page 13,
Election officer.
in
Lordship.
connection with Lok Sabha election 2019.
Correct, correct.
So election officer is under the Election Commission of India.
Yes.
Yes, there is a party, Lordship, resolution number
Number
4 and
one.
5, Lordship.
How about 2?
Lordship, respondent number 4 and respondent number 5. Election officer is the respondent number 5, Lordship.
That's fine. How about respondent 2?
Election Commission of India.
India, Lordship, yes, yes, Lordship.
Why don't you withdraw and file afresh instead of filing an IA for deletion and another IA for you withdraw, file afresh. Mr.
A not, Lordship. A
A
not.
A not.
Not.
Leonard Council for the petition of praise for withdrawal of this petition. With liberty to file afresh. Mr. M. Chikel and Governor Advocate appears for the respond number 1.
1 and 4.
1 and 4. And Mr.
R. Dubey.
R. Dubey and Council affairs for the respond number 2. With petition dismissed on withdrawal with liberty as well. You have filed.
3.
The petitioner here was awarded a contract for providing architectural consultancy services for constructing a college at Golaghat. So the work is complete. His bills have been released, but an amount of rupees 2,24,096 rupees has been withheld as security deposit. Whereas he had already paid the original security deposit, that has also been released. So he's aggrieved by that.
Okay. Who is the respondent?
The principal respondent would be the chief engineer, PWD buildings here.
PWD. PWD would be Gogoi.
Perhaps Mr. Nayak. Yes. Oh, Mr. Gogoi.
Who is Gogoi? Just sketch all of him.
Very well.
We'll take up after.
Very well.
4.
Last occasion, Lordship has directed to dispose my representation regarding extension of the period, Lordship. As per rule 148(2), they can give 3 years.
1 minute.
Would be there.
What has it been disposed?
Lordship, as per information, I have received one copy today itself.
Let us see.
It is Assamese, Lordship.
Oh.
Lordship, at this stage, we have to take the instruction regarding challenging this order also. Because Lordship, under section 148, subsection 3, there is a extension period is 3 years. They can give 3 years minimum. And Lordship, as per earlier order, when I have been allotted, as per Honorable High Court's order.
Okay, MS.
Major Lordship, we have disposed of the representation, rejecting their claim on the ground that Lordship, we have extended twice, Lordship.
Okay.
First for 7 months and next for 1 year, Lordship.
You are Mr. MS.
Ardeka, Lordship, and as per rule, Lordship, rule 2.
Let him get his instructions. MS Ardeka, learned standing counsel.
Lordship, I am appearing for senior counsel BD Das, Lordship.
Respondent number,
Learned counsel appearing on behalf of Mr. B.D. Das
Respond number 3 and 4.
for the respond number 3 and 4. Submits that pursuant to the order dated 13/3/2025 passed by this court. The respond number 3 has considered the representation made by the petitioner. Has disposed of the representation made by the petitioner by rejecting the claim of the, by rejecting his claim. Correct,
Yes, Lordship. On
Para. Mr. S.K. Goswami, learned counsel with the petitioner, prays for some time to enable him to receive instructions.
and period has been, Lordship, the last date for submission of tender has been extended up to
24.
24. Originally it was 19, it was extended up to 24.
So you give you, when do you want?
Lordship. Before 24, Lordship.
Before 24 is the Monday.
On 24, Lordship, on 24.
List the
Because,
matter on 24.
because I have no option, I have to participate. If it
You
is
have to
rejected.
participate.
Second also same, Lordship.
Let us see. Same order.
This is regarding, Lordship, original, first one Shok Bazar, next one is Truckstyle.
Okay. Pass same order.
Stabilizers.
7.
May I please, Lordship?
Hmm.
Lordship, the petitioner before the honorable court is a contractor, Lordship. So what has happened, Lordship? The tribal affairs in BTC Kokrajhar issued the NIT, Lordship. Then what happened? The
Where is the
petitioner being a
Where's the NIT?
NIT is phase, Lordship,
And if you want,
14 to 38. Yes, page 14, Lordship.
yes,
For 15 crores, Lordship.
for supply of blankets.
Blankets, yes, Lordship.
Hmm.
Then the petitioner being a qualified bidder, he submitted his documents electronically and write the e-bid evaluation minutes, Lordship. It's in page 40. His bid
Page?
was
Page
40, Lordship.
40.
Yes, Lordship. 40 and 41, Lordship. His bid was rejected, Lordship. Being aggrieved of that rejection, Lordship, he is before the honorable court, Lordship.
Where's the rejection?
Lordship 41.
Ah.
Para 5. He, the petitioner is the proprietor of New Saha Brothers, Lordship. The firm has not submitted, Lordship, may I read, Lordship?
Hmm.
The firm has not submitted the valid trade license in BTC and financial capability as per clause 6.5 and 6.9 of the tender document respectively. In the clause 5.2 of the tender document, the authority asks to submit past work experience having similar work done in the entrusted departments of BTC in the financial year 2023-24 and 24-25 having a project value of more than 4 crores. New Saha Brothers have submitted documents of work done having a project value of more than 4 crores, but he has found that the work was from the Director of Women and Child Development prior to financial year 2023-24. So the committee decided to consider the bid as technically disqualified. Lordship, he has submitted valid trade license. He has given also the financial capability, and also he has not submitted the tender documents manually. He has submitted it electronically, Lordship. But there was nowhere it was said that it should be only submitted only through manual procedure. He has submitted online procedure, Lordship.
What
And-
does the, what
And
does
he has the trade license which is valid for BTC, Lordship.
where's the trade license?
Trade license is, Lordship. Page 43, Lordship.
Hmm?
Page 43, Lordship.
43.
Yes, Lordship. It's a type copy, Lordship. But the original copy is in 45, Lordship. Yes, also has the financial capacity, Lordship. Yes, Lordship.
And financial capability,
Lordship, it was somehow mistaken, not annexed, Lordship, that I have that. Will file an additional affidavit regarding that, Lordship.
you file an additional,
Yes, Lordship. But I have the copy of that, Lordship.
let us. Yeah, Bora.
Lordship will see the minutes, my lord. This is the minute dated 22/2025, and that minute has not been challenged. In the minute itself, that a rejection is there. He has only challenged that there is a rejection. That minute has not been challenged. Yeah, here it is only rejection order, which rejection is challenged, minute has not been challenged. That minute dated annexure 3, page number, annexure 3, page 40, that is minute dated 22/25. Lordship will come to page number 16. He is saying that manually he has not submitted the, admitted that manually he has not submitted the tender papers. Lordship will come to the note. Second, technical bid submitted manually will be accepted till 29/1/2025 up to 12 p.m. This is mandatory. They have to file that particular thing manually. Now, next language, online mode of submission of technical and financial is mandatory. He have to find, this is also mandatory, and other also manually also file. We have to submit it. And is admitted fact manually that tender paper has not been submitted.
Also, there nowhere it has been stated explicitly that it should be manually submitted, Lordship.
Now, Lordship will come to the minutes, my lord, page 41. The reason given for his rejection, my lord. I'll read it, my lord. Mr. MS News Borders, RNB, wrote, so, Mr. Has not submitted the tender document manually. That is one. The firm has not submitted valid tender license.
Trade license.
And valid trade license. That is in BTC of financial capacity as per clause 6.5 and 6.9 of the tender document respectively. In clause 5.2 of the tender document, the amount asked for submitted past work experience with similar work done in the interested department BTC for the financial year 2023-24 and 24-25, having a project value project value of more than 4 crores. So has submitted the document of work done having a projected value of more than 4 crores. But it is found that the work was for the Director of Women and Child Affairs prior to the financial year 2023-24 and 24-25. So the committee decided to consider the bid as technically disqualified. There are 4 grounds, madam. One is manually it has not been submitted. One is valid trade license, similar work, and document submitted is prior to 2023, 24, 25. Let's will come to the next page, madam. This is the completion certificate of earlier work which was allotted in the year 4, that is work order is given, my lord, 4/12/2021, not of 23-24 or 24-25. And only certificate has been taken out on March 2023. From top, there is a date, my lord, 16 March 2023. First, it is manually, it has not been submitted. That completion, that 2023 is not there. Now, Lordship will come to the trade license. What has happened in the trade license? Here, Lordship will come to page now 45. Down below, my lord, in that 45, this is the original copy. Down below, Lordship will find that the trade license is valid for 1/4/2021 to 31/3/2024. 22, my lord.
No, next page.
Next page, my lord, show you. Next page, my lord. For 2023 year, he had not renewed it. He had renewed for the year 2024-25, 24 to 25 on 13/2/2025. When he realized that he doesn't have a valid trade license, he then renewed it.
Okay.
That's the reason that it is not valid.
Lordship, only I am in the ground regarding in the minutes, Lordship.
How about the minutes?
Yes, Lordship, regarding minutes, Lordship.
You agree by the minutes?
But we have already we have submitted in our petition, Lordship, that rejection order related to the tender, Lordship. We have
What
challenged-
is the rejection order?
It's a minutes, Lordship, the
Yeah.
minutes, Lordship.
Are you challenging that minutes?
Lordship, we have challenged the tender, actually, the tender NIT, Lordship.
You
By which,
participated in the tender and then you are challenging the tender, NIT.
Lordship, the rejection order. Rejection order
Rejection order is, where is the order?
Lordship, yes, it should be the minutes, Lordship.
Then, are you challenging this minutes or not?
We have mentioned the stay award of the tender and the tender number, so and so. Lordship.
How do
Like-
I state unless you challenge this minutes? It's up to you.
As it's related to the tender, Lordship, that's why.
If you want to withdraw and file afresh, that I can give you.
Lordship,
Otherwise,
we'll do it then, Lordship.
no ground.
Withdraw it and file freshly.
Mr.
M. Bhuvala.
M. Barwa, then counsel for the petitioner, press for withdrawal of this writ petition with liberty to file afresh. Mr. S. Bora, then standing counsel appears for the BTC authorities. If petition is dismissed on withdrawal, with liberty as paid for. You can take back that,
Lordship. Obliged.
8,
May I please?
Hmm.
Since petitioner has not been paid for supplying surgical items to the
how
respondent.
much?
In item number 8, 72 lakhs 40,000.
What is the amount?
One is prayer portion, that's it. 72 lakhs 79,200 in prayer portion.
Yes. Instructions,
Yes, Lordship.
instructions or notice?
Instruction not to this, Lordship, may I
Third,
to
Mr.
B.
bring
Fukal.
instruction.
D. Fukan and counsel for the petition. By way of the present petition. The petitioner is claiming for outstanding dues
72 lakhs.
amounting to rupees 72,79,200. Stop. Issue notice. MS
D Bora,
A. Bora,
D Bora. D Bora,
D. Bora, the standing counsel,
Health Department.
Health Department, appears on behalf of all the respondents,
Respondent.
on behalf of all the respondents. As such, normal, extra copies. Respondents are allowed to file affidavit, list of the votes.
Yes.
9. 9 is also same, Lordship. Here the amount is
Nine also same
Same.
order only, huh?
amount is only
Except the amount will be
10 lakhs.
10,47,280.
Deeply obliged.
Like,
10,
May it please your lordship. Lordship, this writ petition has been filed by the writ petitioner, my lord, for non-payment of his hiring charge bills of his vehicle, my lord.
How much?
My lord, 28 lakhs 66,632, my lord. Para 6 of the writ petition, my lord, I have mentioned it in there. Para 6, my lord. And the hiring orders starts from, my lord, Annexure A Kohli, my lord, page 11, my lord.
Chitia,
Yes, my lord, it should go on.
third, Mr.
S. Upadhyay, my lord.
Is Abadial, by way of the present petition, the petitioner is claiming for outstanding dues amounting to rupees 28,66,632.
Yes, sir.
Stop. Issue notice. Mr. M. Chitia, then government advocate,
All right.
enters appearance on behalf of all the respondents. Extra copies. Respondents are allowed to file. Extra copies.
Deeply obliged, my lord.
11,
So this is regarding non-payment of admitted contractual dues. Lordship would kindly come to the last page, page 45. Point 15, your lordship, below, your lordship, point 15. 44 lakhs 13,894 amount to be released now.
Go ahead.
No, it will be the deputy commissioner problem. We both will have the instruction.
You want to get instructions or file affidavit?
Can have the instruction. Written instruction will do, my lord. Whether it is a admitted amount or not, that is the issue.
Okay, heard Mr. B. Bhartwaj, learned counsel. By way of the present petition, the petitioner is claiming for outstanding dues amounting to rupees 44,38. Mr. M. Chittian, learned government advocate, as well as Mr. B. Gogoi, learned standing counsel, PWD, shall receive their respective instructions by the next date fixed. Stop. List. When?
My lord, immediately after the viewing occasion, no. 24th. 23rd, my lord.
23rd.
Well,
My lord, I am a contractor, my lord. I have dues of 15 lakhs and all. But what happened, my lord, your lordship, earlier occasion I came, your lordship directed to pay.
Where's that order?
That order, my lord. At page, annexer 12, my lord, page 26, 27. My lord, your lordship can skip to page 28, para 6, last para. In view of the above.
Yes.
My lord.
Then what happened?
Thereafter, my lord, I submitted this order. They did not pay till date. Every time we approach, my lord, they said that a payment will be made. And subsequently, my lord, after a lapse of more than 1 year, my lord, they said that it is not possible to pay because there is no fund. So that position has been cleared after 1 year. 1 year, 3 months like this.
You can't file control. Okay. Who is the respondent?
My lord, respondents is the irrigation, my lord.
Irrigation department.
Chief engineer, irrigation, executive engineer, and superintending
They
engineer.
have a standing council?
Yes.
Hello.
Who is the standing council irrigation?
They were sharp copy, my lord, at the time of filing. That is in record. Hello.
Let's wait for him. After some time we'll come.
Hello.
After some time.
13.
And we have to call, my lord. We have to call. them.
Let's see. Let's.
My lord.
Rashid, kindly come to page 22, my lord. Annexure B. Earlier, we have approached this honorable court, and this honorable court was pleased to pass an order on 25/11/24, paragraph 2, my lord. Challenging a demand notice, my lord. Demands of the petitioner in respect of notice demand dated 12/11/24 issued by the respondent. Number 3, whereby an amount of so and so was demanded as an amount towards provident fund payable by the petitioners to the respondent authorities. The details of the amount payable are enclosed in the said communication. The Honorable Council petitioner submits that the petitioners had earlier referred a writ petition number so and so, another one previous one, my lord, and submits that an order dated 28/6/24 was passed by this court in WPC number so and so, where notice of similar nature was issued. This court by the said order has suspended the enforcement of the said notice till the next returnable date. Subsequently, on next page, my lord, 13/7/24, on the basis of instruction furnished by the PF authority, the writ petition was disposed on the ground that in terms of the communication placed before the court, the earlier impugned notice was considered to have been withdrawn. The notice that we have challenged, they have withdrawn. That is why, my lord, it was withdrawn. Thereafter, my lord, on the basis of this submission, lordship, interim was passed. Next page, lordship will find page 25, page 6, my lord. Meanwhile, in the event the department proceeds in the matter in respect of the notice of demand dated so and so issued by to the petitioners, no final order shall be passed without the leave of the court. Thereafter, what they have did without taking any leave, my lord, they have dared without giving any importance to this court, my lord. Lordship will find page 26. They have attached my garden, my lord, my only source of bread and butter, my lord, from which I earn. They have snatched that away, my lord. Lordship, as a result, my lord, I am facing difficulty, my lord. Somehow I have paid all the labor dues, my lord. Somehow I am managing to pay. Thereafter, lordship will find 47 page, my lord. I have come up with a contempt case, my lord, and the learned, this honorable court, after being satisfied, my lord, issued notice to them. They are yet to appear. So my limited prayer, my lord, let this operation of the impugned notice of attachment be, for the time being, be stayed, my lord. And the illegal order they have passed, my lord, Annexure C 27, my lord. I am ready to pay the amount, my lord. But there is a dispute. I am ready to settle that also. Just give me time, my lord. And court has categorically said that don't pass any orders without taking leave of the court. And even then, during the pendency also, they have dared to do so.
Yeah, I'm preparing for the clear organization.
Okay.
Lordship, may I take your lordship attention to page 20? Initially, that when the demand notice was issued to him, there is a pending dues of PF amount, not the salary amount, amounting to around 1 crore 20 lakhs.
Whatever, my lord, they should
have. Yes, there's the amount of 1 crore 20 lakhs, which he said he will pay and dispute it. So that was withdrawn. Subsequently, we issued the second demand notice because there was no conciliation, or which was issued on 12/11/2024. Your lordship will find it page 20. If I may read the third paragraph, your lordship. You are informed that in case of failure of deposit of the said dues, steps should be taken to realize the amount in accordance with the provision of the section 15B and 15(2) of the, this act, Assam Tea Plantation Provident Fund Act. The procedure is like this, your lordship. After the demand notice, he is given ample time. If he fails, then we attach the garden and then we appoint him itself as the receiver. At present, he is the receiver. We have not snatched away the garden from him. Because the attachment is that so that he does not sell or create third-party right. Otherwise, we will have nothing to recover from him. And after that, if still he fails, then we issue auction notice. The procedure is same like the income tax and the recovery by the banks. Even after issuing the auction notice, you will have time to redeem it. If only on failure only, then we will have a right to sale. That is when we will have to take leave from this honorable court. That's what the honorable court said, your lordship will see at page 25. Meanwhile, in the event the department proceeds in the matter, in respect of the notice of demand that issue to the petitioner, no final order shall be passed without leave of this court. Now, they have asked us to proceed. The demand notice has not been stayed. If it is not stayed, then we will have to take the next step, which is this demand notice was issued in 31 in the month of November. If your lordship sees the now impugned notice, that is at
let them file affidavit, my lord, whatever they are saying.
Let me just a minute.
So change this 10 now and then.
Demand notice at page 20. 20. Impugn order. 26 is the impugn order.
Yes.
Here, if your lordship sees the second paragraph, whereas the undersigned in exercise of power conferred under section 15B, which I have read in the demand notice, your lordship, so and so, and you are hereby prohibited and restrained until further orders of the undersigned from transferring or charging the undersigned. So what we are doing is that you don't create. He is still as a receiver from this was issued in the month of December, and today is March. He is not aggrieved. He is still running the garden. And he's defaulting. Still date he has not.
Yes, it is not written that I am the receiver, my lord.
He is still the receiver. Is he denying?
My lord, I cannot sell the garden, my lord. at least somehow I can, this is the growing season, my lord, I can harvest the tea, my lord, so that I can earn my livelihood. They have taken that away, my lord.
That you can proceed.
That you can proceed. He can still stand. We have only attached a garden. He is not prohibited from operating the.
Not to
from the
create a
manage-
third party. That's
That's
not to
it.
create a third party right.
Yes, that's,
You can proceed.
he can sell the tea leaves.
You file your affidavit.
Yes.
I'll issue notice.
My lord, interim may be allowed, my lord.
No,
He's already protected by the previous order.
Third,
If
Mr.
that is so, that it may be observed that I can at least part of the garden I can sow so that I can give. the
You are
balance-
Mr.
DK Bakshi, my lord.
Heard Mr. D.K. Bakshi, let me complete. Issue notice. You are appearing for
I am appearing for all the respondents, 1, 2, 3,
Mr. R. Sharma,
as standing counsel.
standing counsel,
80, 80, PF, PF.
ATPPF,
Yes.
appears on behalf of all the respondents. And press for short time
Yes.
to enable him to file it. After this. Press allowed. Extra copies of the petition be furnished, huh? List one, when?
2, 3 weeks. This may be tagged with the other writ petition or this other
On
6187.
We'll have it on 9th April, 9 April, along with WBC number 6187 of 2024.
In the meantime, my lord, I can proceed with my, this garden activities, my
That
lord.
is, you have been doing it after 31st December,
Yeah.
okay?
Yes, yes, yes.
All right.
3,
Mr. Gogoi is here.
I will have
Oh,
I thought three.
Notice may be issued.
What is this?
Lordship, security deposit has been withheld, your lordship.
Heard Mr. K.P. Pathak, Learned Counsel for petition. You want notice or instructions?
Notice, my lord.
Issue notice. Mr. K. Gogoi, B. Gogoi, Learned Counsel, PWT. Enters appearance and accepts notice. On behalf of respondents, not all.
Finance section, finance section. I think we will
All
Education,
of technical 4, my lord. SMD system may be recorded. For 4 SMD
okay,
system.
don't say them, Ms. B. Gogoi, Understanding Counsel, PWT and Finance Department, huh? Enters appearance on behalf of the
It
respondent,
will be higher education, K Google, my lord.
1, 2, and 3.
For 4.
1, 2, 3, and 5.
Yes.
Hmm. Mr. K. Gogoi, Understanding Counsel, Higher Education, applies for the respondent. Respondents are to file extra copies.
Oblation.
12,
Yes, outstanding dues.
Notice by court.
By way of the present, the petitioner is claiming for outstanding dues amounting to rupees 15,21,896, correct?
Yes, ma'am.
Stop. Issue notice. Mr. Nobadia, Understanding Counsel, Irrigation,
All the respondents.
Department appears on behalf of all the respondents. Notice on respondents are complete, however, extra copies. Respondents are not to file after. Please.
Lost,
the
lost.
copies.
53 of
We are
supplementary
trying to
list.
give extra copies, madam.
Yes.
Obligation. My lord, in this case, an NIT was issued by the respondent, which is at page 44, my lord.
Page.
44, my lord. HSCL invites online percentage rate open tender from experienced and eligible contractor for construction of training shed of size number so and so with allied services and development was at Sirikona ground for
DGAR Assam Raipur, Shillong. Now, my lord, the petitioner as well as 3 other tenderers participated in the tender, my lord.
When is the last date?
Last date, my lord, it was, in this case, my lord, opening date was 21/2024.
Hmm?
Opening date for the technical bid. So technical bid is opened. And I am here, your lordship may kindly see the summary of technical bid evaluation, my lord, at page number 72, my lord.
Yes.
In technical bid, my lord, they disqualified me, my lord.
On what grounds?
On the ground, my lord,
Where's your firm?
serial number 2, my lord, Meghalaya Construction and Supply Company, Nagaland. And what is the ground, my lord? They disqualified due to non-submission of valid EMD, FDR against EMD, not lien mark in favor of the Hindustan Steelworks Construction Limited, which was not complied with as per NIT clause numbers so and so. No specific ground is mentioned, my lord. And my EMD is there, my lord. I complied all the terms and conditions at page number, my lord, 43. My EMD there. It was also submitted, hard copy was also submitted, soft copy was also submitted. There is no discrepancy found in this EMD, my lord.
Okay.
There must be, now, your lordship may kindly see, the only one is qualified, my lord. This is Satyam Contractors Private Limited. So loan tender is there. There is no competition, my lord. Now, in a similar manner, my lord, in another contract, my lord, at page number 103, my lord.
103.
103. Technical bid evaluation summary is there. Here also the same firm is qualified. Satyam Contractors Private Limited. And they again disqualified me, simply saying you have not fulfilled the clause number so and so against the EMD, my lord. In another case, my lord, similar manner, same at page number 136, my lord. Same formula they have again qualified here. And others were disqualified. On the same ground, my lord. Only clause they have mentioned. What is the fault? What is the mistake? It has not been pointed out. So this is a clear case of favoritism, my lord. They are favoring the Satyam Constructors Private Limited and discriminating me, my lord. And as per Central Vigilance Commission, my lord, if there is a loan tender, then it should be cancelled. They are not cancelling, they are going to award, my lord. There is no competition. It is a loss to the public exchequer, my lord. And the entire purpose will be frustrated, my lord. If there is no competition in the rate, my lord.
Yes, Roy.
I'm for respondent number 3, lord. Notices to fill.
Public sector, my lord, and they are behaving like that, my lord.
What is the stage of the NIT now?
My lord, they are going to open the financial bid, my lord.
When?
Date was not fixed in the NIT, my lord. Later on, it is mentioned that later on date will be. Shortly, they are going to open, my lord. So your lordship may examine what is the fault in my EMD, my lord. Everything I have complied. No other mistake or discrepancy is pointed out, my lord, by them. And how they are favoring one In all tenders, only one firm is qualified and others are disqualified. And same respondent, my lord.
Okay. You have anything to say?
No, Lordship, I'm taking.
So notice may be issued and in the meantime, status quo may be maintained by them, my lord.
What status quo?
Status quo, further process may be stopped, my lord. Or they may not finalize till the
Where are
further
the
order.
parties from? Where are the parties from?
Parties is from Guwahati. One is, main is, my lord, respondent number 1, 2, and 4. 4 is from Guwahati. Same, they are also having the office at Guwahati, regional office.
You serve dusty service?
Yes, I can say that is.
And you will take up on Monday or Tuesday?
Yes, yes, my lord. In the meantime, status quo.
No status quo. Till Tuesday, no status quo. Interim will be considered on Tuesday.
Within 1 week, my lord, nothing will happen.
But Mr.
R. Hussain.
Then it also could. The petitioner participated in the notice inviting E-tender within bracket NIT number HSCL oblique CPG CPG oblique NEZ oblique IDAR oblique Shrikona. You will get it in page 44. Oblique 404 oblique 2025 oblique E-036 dated 3/1/2025. Is this the NIT, isn't it?
Yes, yes, my lord.
With regard to
With regard to this construction of training
construction
shed.
of TRG shed of size within bracket 50 m into 48 m close bracket with allied services and development and development works at Shrikona GRN. I marked it all page 44. Thereafter, comma. The in the technical bit evaluation summary, the case of the petitioner along with 2 arbitrators were disqualified and only one MS Satyam Contractors Private Limited party was found qualified. Stopped. Being agreed. Before this court by way of the president. Stop. Issue notice. Mr. S. Roy, Leonard, CGC, appears on behalf of the respondent number 3. Stop. Considering the urgency involved, petitioner is directed to take steps for service of notice on the respondents 1, 2, and 4 by dusty service to the registry of respondent within a period of 2 days.
My lord, on respondent number 4 by dusty service as well as registered post. Because only respondent number 4 is from Guwahati.
How about this? Okay, you can't take dusty service.
On respondent number 4, my lord.
Okay, petitioner is directed to take steps for service of notice on the respondents 1, 2, and 4 by registered post AD within 1 week. Within 2 days from today. Additionally, petitioner is also permitted to cause service of notice on the respond number 4 by justice service to the registry of this court within a period of 2 days from today. Draft of petitioner shall file an affidavit to the reach the matter on 25th for consideration of the prayer for it.
Much.
54,
May I please, yours? I have been here to work order milk for sale of milk in the milk stall at platform number 2 and 3 of Rongya railway station milk. And after getting the work order milk, I applied. I requested the authority milk to sell my additional catering items at the it is very low. The sale of the milk order is very low. That was rejected. But the same authority milk in earlier occasion, this is a established procedure of the railway to allow the petitioner and the other vendor to sell additional items by revising the license fee of additional 10% of the about the existing license fee, my lord. I will kindly see page 83. This is the work order issued to me, my lord.
Okay.
On a work order for operation of milk stall at platform 2 or so and so. Thereafter, on page 86. I applied for granting my lord permission to sell additional items, my lord, food items, my lord.
Food items.
Yes, my lord. Because there is a clause in the tender itself, my lord. That
Where's the
yes, my lord. There is page 51, my lord. This was a special condition of contract 1, my lord. Item for milk stall. 1, milk and milk products as per MRP, other than those as approved by the railway board, general railway from time to time. Then the note 1, the license should obtain a prior payment of the tariff at which the products should be sold. Now, page 88, my lord, can you see, my lord? On the second time, I requested the authority, my lord, to allow us, man,
Yes.
in reference to the earlier permission granted by them, my lord. Now, my lord, in reference, my lord, see, my lord, I have referred to letters, my lord, that is 14/9/22 and 22/3/2024. My lord, find it, my lord, page 160 and 163, my lord.
Page
160, my lord. But this has been allowed by the same authority, my lord, irrespective of platform number 1 of the Rongya railway station, my lord. I will kindly see to so and so petitioner permission to sell additional items in milk case platform of Rongya railway station. Then approach the above subject. It is for your kind information that the corporate competent authority has permitted for selling of under mentioned additional items only in the milk stall at Rongya railway station platform as given as under. After this column, my lord, the revised license fee your respective milk stall by depositing additional 10% over the existing license fee, which is as under. Now, they revise the license fee, my lord, of additional 10%, my lord, over the existing license fee. They have to allow the petitioner in earlier occasion also, my lord, to sell the additional items also, my lord. Now, similarly, my lord, page 163, my lord. It is in respect of Gureso railway station, my lord.
That was in the past.
Yes, my lord. This is the established procedure, my lord. This is regular, my lord.
How do you say it's established procedure?
Yes, madam.
How do you say it is established procedure?
Yes, madam. Because, my lord, in 22, 20, and 20, and even 2020 also, my lord. My lord, kindly see 166, my lord.
How?
So, whenever any work order has been issued in respect of milk stall, my lord, I or along with the other vendor applied, my lord,
Then what happened after your application?
Now, my lord, kindly see, my lord, page 89, my lord. My request has been negated by lord, without showing a reason, my lord. Only said by in this connection with the above, it is informed. to you
Anyway,
that-
you're running the milk stall
Yes, my lord.
at Rangya,
Wrong, yeah, my lord. In platform number 2, my lord. The present one, my lord.
2 or 3?
2 and 3, my lord.
2 and 3.
Earlier one, my lord, and the Gureshwar, my lord. Where they have allowed me to sell my additional items, my lord.
That was in 1
One, my lord.
bedroom mall.
Yes, my lord.
Now you're concerned with 2 and 3.
2 and 3, my lord. Because the same authority allowed me, my lord. So
That
I
is-
have the expectation, my lord, legitimate expectation that case.
Yeah.
I have to obtain the instruction.
Oh, you get some.
Lordship. He is running the stall now. Let me have the instruction.
You want notice or
Notice, Lordship.
how it is brought up?
In the they could take the instruction, my lord,
I will take.
because I have to sell the additional items, my lord, because the rate is, I am the highest bidder, my lord. Because revised price is
This protocol and a counsel for the petitioner. Issue notice. You are appearing on behalf of all.
All the
Mr. S.S. Royal and the CGC and this appearance on behalf of all the respondents. Accordingly, notice and respondents are complete, however, extra copies. Mr. On top, Mr. S.S. Royal and CGC and this appearance on behalf of all the respondents. And praise for, how much time you require? 2 weeks?
2 weeks, Lordship.
Praise for 2 weeks time to enable him to receive instructions. Price allowed. List on
2nd of April, my
Third April, Lordship.
3rd of it.
in the he'll take instruction, my lord.
That's what I've said.
Yes, man. Okay.
55.
May I please, Lordship? My lord, the Sapodgaon municipality in the district of Dhuri issued tender notice, both offline and online. Lordship may kindly see page 20. That is the offline tender notice, page 20, against certain works. Page 20, bottom kindly see. Against item number 2, I offered my tender. This is one. And there were some other works which were invited on online ballot. That Lordship may kindly see page 22. Here against item number 3, 4, and 5, I offered my tender papers. And in the long run, my lord, Lordship would see there was some comparative statements. And in comparative statements, my lord, my bid value was the lowest. Lordship may kindly see page 27. I am Taposh Lodrai. There are some other persons also. My rate was the 16 lakh 85,049, and others are higher than me. So in that view, my lord, against all these 4 items, my bid value was lower than the other bidders. Even then, the Sapodgaon municipality, due to extraneous consideration, cancel the notice, that is online and offline. Kindly see now page 39. This is to notify that the offline and online tenders invited under 15th Finance Commission Bide number so-and-so dated so-and-so and number so-and-so dated so-and-so are hereby cancelled by the Technical Evaluation Committee of 5th Finance Commission of Sapodgaon Municipal Board. Now, my lord, without showing any reason, without asking me, because I had a legitimate expectation to get the tender work, but that chance was not given. And what they did, my lord, now Lordship kindly see page 40. They issued re-tender notice and fixed 21/3/25. On that day, tender paper would be opened. That is day after tomorrow, my lord. Now, my prayer is this, my lord, there are absolutely no necessity to issue re-tender notice. And in the re-tender notice, my lord, offline and online works are clubbed together. Normally, that is not done. Offline should be there, online shall be separately. But here, both online and offline, for instance, Lordship may kindly see page 41, serial number 5, construction of general public toilet at Sapotgram in the premises of Sapotgram Bengali Higher Secondary School, ward number 2, Sapotgram under the tight grant of Finance Commission. So this was earlier in the offline, is by offline tender. Now it is clubbed together with both the offline and online tender works have been clubbed together and has passed the impugn order. Now my submission is this, my lord, when I was the lowest tender, so I was the better person to be provided with the works. And my lord, they have given the condition that the tender, the person who will submit tenders, they must have 3 years experience. Kindly see page 20 bottom. Second para, after third lines, the credentials of last 3 years of similar nature of work, bank guarantee, so 3 years.
Page 20.
Page 20, my lord, second para, after 4 lines. 3 years similar nature of work experience should be there. But I have 15 years of experience, some work performance certificate regarding my proficiency in such type of works. I have annexed since the year 2010, page 13 onwards. I have annexed. So I have 15 years of experience. Now my submission is this, the cancellation order which was issued without any legal ground, though my value was the lowest bidder and I was, my bid value was lowest and reasonable, not unreasonable. So they are trying to give it to some businessman due to extraneous consideration. And that's why I was not issued any notice and no hearing took place, no reason is provided, only that is cancelled. Similarly, it appears that the order itself is violation of principle of national justice. My humble, and the date fixed on 21/3, that is day after tomorrow. So my prayer is this, my learned friend may bring instruction until then no tender papers may be open on 23, on 21.
Whole tender is cancelled, my lord. It is cancelled on 17/2, my lord. Today is my lord 19/3, my lord. After 1 year, after 1 month, he has come, my lord. Even my lord, whole tender has been cancelled. It is cancelled by the municipal board, my lord.
Yes.
In that case, my lord, notice to go, my lord, notice, my lord. Whole tender has been cancelled. Tender submission last date is on 23rd.
Are you participating in the retender?
No. I have not participated. Because
may
I
participate,
have
my lord.
challenged that. Well, my learned friend say about 1 month. My lord, actually, everything is done in a secret manner. So I had to collect from various sources and thereafter case has been filed. So let my learned friend bring
How do you
instruction.
know this notice is of 17/2/2025? It
Yes.
was cancelled on that day.
Yes, ma'am.
And copy was issued to the district commissioner, district commissioner, Bilasipara.
Even my lord, retender notice was also issued on 6th March.
My
You
lord,
come quite
Lordship
late.
would see page 21, sorry, page 39, page 39, which is the cancellation order, no copy was furnished to us. Page 39, kindly see, only district commissioner and co-district commissioner. So we had to collect some various sources and lastly came to know and immediately filed the case and it is listed today. There is the abnormal delay, man.
You submit your tender papers
Yes.
in terms of the retender. Meantime, of course, we are not dismissing your petition as such, but then we'll consider what happens.
Yes.
Resubmit, there is no problem. But thing is this, what was my legitimate expectation that has been taken away by way of no legal process.
Okay. But Mr. M.U. Mahmood, stop. The petitioner participated. in a notice inviting tender, number SMB stop 15 FC oblique 2024-2025 oblique 460 dated 14/11/2024. This is offline.
Yes, that is offline.
Participant in the offline.
Yes, and 22 online.
With regard to construction of boundary wall in the northern and southern side of Sabatgram Municipal Office premises under untied grant of 15th Finance Commission, as well as in the online invitation of bid, within bracket, IFB, dated
Same date.
14/11/2024. With regard to the items at serial number 3, 4, and 5. Stop.
Yes.
Stop. Para. Thereafter, in terms of the POQ summary details, the petitioner was the lowest bidder.
Yes. Comparative
No, no,
statements are also
uh,
published.
Don't say like, it is the case of the petition that in terms of the POQ's summary details, the petitioner is the L1 bidder. Stop. However, the executive officer, Sapatgram Municipal Board, by a notice dated 17/2/2025, cancelled both the offline and online tenders. Without citing any reasons. Stop. Thereafter, a tender notice was issued on 6th March 2025 by clubbing all the items of the earlier offline and online tenders. Stop. It is the case of the petition that in the earlier offline and online tenders dated 14/11/2024, the petitioner was the L1 bidder, and as the bid amount was a reasonable amount, the respondents, particularly the Sapatgram Municipal Board, should have awarded the tender to the petitioner, or should have awarded the work to the petitioner for the items that the petitioner had submitted its bids. Stop. However, without citing any reasons and without giving notice, the notice dated 17/2/2025 was issued. Stop. Para. Issue notice. Mr. M. Chitia, learned governor advocate.
1 to 5, madam.
Enters appearance on behalf of the respondents, 1 to 5. Stop. Extra copies. Petitioner takes steps for service of notice on the respondents 6 and 7 by registered proceeding within 2 weeks, 2 days. Within 2 days from today. Stop.
The same may be also permitted to the Sapatgram municipality. Justice service may be permitted to Sapatgram municipal board.
Additionally, petitioner is also permitted to cause service of notice on the respondents 6 and 7 by registered post AD, by justice service to the registry of this court. Within 2 days, can you do it within 2 days?
Let it be next week, I will, because certified copy has to be obtained.
Within a period of 3 days from today, stop. Thereafter, petition shall file an affidavit to the effect. Stop. Mr. Matter, again on. Can you have it on 26th
26. Yes.
of March? List the matter on 26th March 2025. For till the next returnable date, comma, the respondents are directed not to finalize the re-tender notice dated 6 March 2025.
Your lordship has
The
indicated.
petitioner is also permitted to participate in the re-tender notice dated
6/3.
6/3/2025 if so advised.
14 of daily list, implement of party.
May I please, your lordship? Lordship, the matter pertains to non-payment of outstanding liability for my vehicle. Lordship, the respondent number 3 has filed their affidavit. Lordship, may kindly come to page 86
Of the writ
of the
petition,
running page.
page,
Page 86, Lordship, the running page. Para 7 onwards, Lordship.
para 7,
Lordship.
yeah.
That with regard to the statement made in paragraph 6 of the writ petitioner, it is to be mentioned that after the release of the said vehicle bearing registration number so and so, which is in the
1
name
minute,
Lordship.
something is wrong. Which affidavit is this?
By the respondent number 3, Lordship,
By the respondent number 3,
running page number 86,
okay.
from paragraph 7, Lordship. That with regard to the statement made in para 6 of the writ petition, it is to be mentioned that after release of the said vehicle bearing registration number so and so, which is in the name of the petitioner, Srimati Siddheshwari Dev, all the pending liabilities against the expenditures incurred for the counter-insurgency operation in Gwalior district were submitted to the Home and Political Department from time to time in form of demand proposal of funds by the District Commissioner Gwalior by letters mentioned above. Thereafter, Lordship, in para 8, that with regards to the statement made para 7 of the writ petition, the answering defendant respectfully states that the payment of the pending liabilities against the vehicle charging charges of the vehicle bearing registration number so and so owned by Srimati Siddheshwari, that is the petition amounting to rupees so and so, only can be made subject to receipt of funds as per requirements which was submitted to the Home and Political Department, Government of Assam by December.
Okay.
So, Lordship, Home and Political Department was not made a party in this writ petition. So, Lordship, I filed a IA for impleadment of the Home and Political Department and the finance.
Anybody? In the IA, you are appearing, Chitya?
Yes, madam.
And CRPF,
CRPF, Lordship, they filed their affidavit.
CRPF is who?
CTC, man. Yes.
Okay. What, Mr.?
S. Mitra. S. Mitra.
S. Mitra, Leonard, counsel for the applicant. Also heard Mr. M. Chitya, Leonard, government advocate. For the opposite parties, number?
1, 2, and 3, madam.
1, 2, and 3. And Mr. who was appearing in the writ petition?
अपनी होमो करना अपनी
कोई तो पेगी जाता
Anybody appearing for the Gogo, you're also the CGC? And Mr. K. Gogo, and the CGC for the respondents, point, opposite parties, 0.5. Stop. By way of the present, the present IA has been filed by the writ petitioner. By the applicant. Who is the writ petitioner in WBC number 3870 of 2024. Praying for impleadment of. Is it 6 and 7?
Lordship, 6 is the finance department, 7 is the home and political.
Page 5. Put A and B, huh? A to A. There is 6 and 7 in your application, isn't it?
Yes, Lordship.
Page 5.
Page 7, Lordship.
No, page 5 also is there.
Yes, Lordship. They are the newly implemented parties. 6 and 7, Lordship.
Oh. As party respondent number 6 and 7 in the settlement petition. On the ground that the aforesaid proposed respondents are necessary parties. Stop. Para. The learned counsel for the opposite parties has now observed. Stop. This court has also perused the course shown in the present application and is satisfied. Accordingly, prayer for impleadment is allowed. Stop. I discourse. In the main writ petition, in view of the order passed today in I number so and so. Let so and so be impleaded as party respondent 6 and 7 in the present petition. The petitioner is directed to file an amended course title within a period of 1 week.
Lordship.
Stop. Who enters appearance? Finance.
I will apply for a 7, my lord.
Mr. M. Chitia, finance. Mr. B. Gogoi, Learned Standing Council Finance. Enters appearance on behalf of the newly implemented respondent number 6. And Mr. M. Chitia, Learned Governor. Enters appearance on behalf of the newly implemented respondent number 7. Stop. As such, no formal steps are required. However, extra copies of the writ petition be furnished to the learned council, to the learned standing council, as well as governor for the respondents 6 and 7. Stop. How much time you require?
3 weeks time. Extra copies of the
Respondents 6 and 7. Allow 3 weeks time to file the respective affidavits.
3 weeks.
Huh?
3 weeks.
Yeah, that's not.
Lordship, may kindly have a date of
Finance may be reflected in the.
List after 3 weeks. Registry is also directed to reflect the name of the learned standing council finance in the cost list.
Lordship, may kindly have a date anytime after 3 weeks. A fixed date, Lordship.
Give a date of.
After view. As per Lordship's convenience, after view.
23rd
Obliged.
April.
Mr. Matron.
56 and 57 of supplementary list. Stay vacating application.
Lordship, kindly pass over the matter for time being, Lordship.
My lord may have this matter on Wednesday because this is still getting petition. It has been disposed of within 15 days. My lord may have it on Wednesday so that I also get instructions and be able to reply and dispose of the.
Is it coming up for the first time?
Yes, Lordship.
So notice has to go there.
26th.
IA. IA number 775, huh?
7.
Correct. Hurt MS.
R. Kakoti.
R. Kakoti, London Council for the applicant. Stop. Issue notice. IOC who appears?
Here for the IOC.
Oh, you're for the IOC, okay.
SC
Oh,
for
oh, what-
TGF.
what-
Ayushel Bongaigaon Refinery, Lordship.
Opposite party. Oh, only one opposite party?
Yes, Lordship.
Okay, then Mr.
R. Sharma.
R. Sharma, London Senior Counsel. Assisted by Mr. P. Fukan. MSP Fukan. Enters appearance on behalf of the sole opposite party and prays for a short time to enable them to file objections. Praise the Lord. List on 26th
26th,
March.
26.
26th.
Apply.
15 of daily list admission.
This matter regarding non-payment of contractors bill.
Affidavit has come?
No, Your Lord, we have not filed affidavit, Your Lord. That instruction has been received, Your Lordship. But as per our instruction, only 3,723 is remain outstanding against.
What is the
Your Lord.
claim of the petitioner?
4,96,000.
Can you file your affidavit?
I may be allowed, Your Lord. We are disputing the amount, Your Lordship.
Heard Mr. M. Barbuya, and the council of petition. MS Ardeka,
Ardeka.
Learned Standing Council, Water Resources Department. Submits that she has received instructions. And prays for how much time?
Your Lordship, 2 weeks time.
2 weeks time to file counter affidavit. Praise the Lord, list of the 2 weeks.
Obliged, Your Lord.
16 and 17.
Here the PWD was supposed to file the affidavit. You have sent it for vetting. Can it be in the next week? It will be filed. Yeah, or after 10 days.
Chitya, you said you are filing an additional affidavit. You have filed it. Anybody appearing for the petitioner? Last time also none appears.
Then what civil adjourned manner. Nobody is appear. And proceed after 2 weeks.
No, you wanted to file
Yes,
affidavit.
we will file affidavit.
None appears for the petition. Mr. B. Gogol and the Standing Council. PWD. Prays for
2 weeks.
2 weeks time to file counter affidavit. Praise the Lord. List up to 2 weeks. Any interim is there? No. There's no interim. MS MD Bora, Learned Standing Council appears for the Transport Department.
Deficit, giving some records, namely the purchase orders and the meetings with the IEM, the discussion of the IEM. Those are the records. But the primary record, which relates to the decision making, because right from the first day when they filed their affidavit, they said that after the meeting with the IEM, we had an in-house discussion and formed an opinion to open the tender of the respondent number 5. But strangely enough, the minutes of that meeting does not form a part of the records which have been forwarded to us. And that is most vital for your lordship to examine what has been done, how they have done. And next thing is lordship. And lordship will find even in the meeting of the IEM, ONGC, I'll just point your lordship to that part where ONGC categorically states, page 188, it starts, lordship. (188) is the minutes, and the relevant portion is
188.
188 is the minute starts at 188. That's a discussion, opinion of the independent monitors, and the relevant portion is lordship at 195. ONGC informed that the work order for fabrication of water treatment plant has lordship got 5.5 by IIT Guwahati has not been considered as educational institutes and not classified as industries. Hence, as per BEC, these works were not considered. To the query, ONGC informed that experience for fabrication in an industry is different than that of other sectors, as compliance of various safety regulations is required in doing their jobs for industry which will not be there in case of other education sectors. Now, ONGC was of the opinion when they formulated the BEC, the code, they were of the opinion that this job, working, fabrication, etc. in oil sectors require far more precautions and safety measures than water treatment plant. And that is the reason water treatment plant was not included. There is a specific opinion of the ONGC before the IEM. Now, after the meeting with the IEM, for good reasons, Lordship, they may change. They may change the opinion, want to make the scope wider and reconsider. But it must be followed by a decision, preceded by a decision-making process. And once you have decided to amend, this would amount to amending because even in the opinion of the ONGC, it is amending, Lordship. Even though now they say to save their skin that it's not an amendment, it's just a generic term. It was not so. And then there is a process. Once you want to kind of make it more lenient, there is a process by which these criteria can be done. It is there in the manual of the ONGC, which I do not find that has been complied with. ONGC has its manual for how it would amend the bit. That manual is very much there, Lordship, in something paragraph 13. What's it? In that manual.
Where is that manual?
I don't have, it's a huge book, ONGC would be having that. I had a glance through in the internet. A portion they had annexed, which is
at least the relevant part.
the portion they have annexed, Lordship, for the labor license, but there's more to it. So you showed me yesterday.
Okay.
12.7, clause 12.7 of the manual. I have soft copy, but it's a huge manual. I didn't print out. Otherwise, I would be, I'll be dictated or accused of giving a truncated document. But that manual is very much there with the ONGC. So ONGC can definitely produce it. 12.7, 12.8.
12.7.
Lordship, it is at 12.17. 12.17.3. And that chapter
of manual.
of the manual, manual 070922. This
What
is
manual is it?
this integrated materials management manual. So they have laid down an ONGC. Lordship of state cannot change, even if it's minor variation. They have to follow a procedure.
Integrated management.
I'm just, Lordship, integrated materials management manual, chapter 12. So you want to, what happens if they have a pre-bid meeting? Suppose they change, whatever is to be done is to be done there. And anyway, Lordship, just common knowledge, a state authority issues a tender, decides to modify it for good reasons, maybe. I'll not question the reasons because I don't know the reasons unless they produce the records, which they have. But that, Lordship, has to be done in a procedure which is legal, which is valid, which will kind of stand the scrutiny of your Lordship. Where is that, Lordship? It's not before your Lordship. Those records are not given. Few pages have been taken out from the records. Some purchase order, meeting of the IEM. That's it. But the main part, the decision-making part is not there. I'm on that, Lordship. If we find that ONGC had complied with all the procedures, then I am out. And Lordship also, otherwise Lordship will find that ONGC knows for a water treatment plant, whether you call it a PHE, a huge PHE in that water industry, that's a different matter. Working in an oil field, which is combustible, which is volatile, is far different than working in a water treatment plant. So ONGC rightly said so, that the safety measures are different. That is what worked in their mind. And the materials management who formulated the tender and the bid, who's the authority of the tender document, knew what was in their mind, not the IEM. And the Supreme Court has said again and again, even the courts can't interpret the tender document. Even if it's ridiculous, it is only the author of the tender document who can release. I placed my judgment the other day. I'll give a list to Your Lordship again. Supreme Court has said that time and again. Only the author of the document can interpret, not the IM. The IM has no business. IM can only examine the tender document from the point of view of the integrity pact, whether there's been any corruption, some kind of unauthorized action on the part either the bidder or the ONGC, not otherwise, Lordship. And plus, even if you read the word etc., what do you read the word? It has to be read etrism generis, because they just left it oil, petrochemical, etc. Now, with that, I cannot bring in a garment industry, even if it's very big. There has to be some logic. It has to be read together in the same thing, which I again also placed a judgment the other day of the Supreme Court on that point. I'll give a note on the judgments to Your Lordship. I will not take much of my time. I think Mr. Saikias also wants to finish it off fast. So these are the points, Lordship. Unless the records are here, I think, if at all, and if they don't have the records, it's bad, Lordship. This opinion making exercise is absolutely bad. Because otherwise, how will Lordship examine? Because Lordship will examine only the decision-making process, not the decision. But Lordship must know how the decision has been arrived. That Lordship is missing. So Lordship, either they place that, and if your Rasmus 5 also has to argue, so I'll place my final arguments after whatever, at one shot. Only this I wanted to point out to Your Lordship over this.
The case is in a very narrow campus, Lordship. If Lordship is pleased to come to page 27 of the writ petition. Bid evaluation criteria 2.0 eligibility and experience of the bidder. The bidder, single bidder, Indian joint venture company incorporated should have minimum 3 years of continuous or cumulative experience in providing a similar service, that is revamping, repair and fabrication and painting of oil field installations, rigs, drilling, workover, chemical industry, petrochemical industry, and any other large industries, and having executed fabrication, repair and painting works relating to the bunkhouses, tanks, mud tanks, tank skids, walkways, floorings, rig equipments, and other major jobs during last 7 years period shall be reckoned from the date of opening of the techno-commercial bid. So the whole case is revolving around this condition. When the eligibility criteria and experience of the bidder is asked, then they should have a 3 years experience in either oil field installations, rigs, chemical industries, petrochemical industries, and any other large industries. So any other large industries will not qualify to mean only the petrochemical industries or chemical industries or oil field installations. So any other industries. So when we first took the decision, we decided that the private respondent who is on the other side, he submitted the documents of his identical work, that is revamping, repair and fabrication and painting work. These are general works. According to him, according to us in the initial assessment, that he had worked in IIT. So whether IIT Guwahati or any educational industries can be considered as under the criteria any other large industry. So our initial perception was that it is not a large industry as because it is an educational institution. Then he went to the independent assessment committee who he was deprived. So that committee opined, that opinion is at Lordship. Page 39, IEM. So a representation was submitted by them, and after submission of the representation, there was a hearing, and an opinion has been given by the independent assessment. Independent external monitors. So they have opined, may I read it, Lordship? Page 39. As per BEC, bidders should have executed job orders, contracts, or similar services of at least 2.01 crores in last 7 years, reckoned from the date of techno-commercial bid opening. In the BEC, similar services have been defined as revamping, repair, fabrication, painting at oil fields, installation rigs, drilling, workover, chemical industries, petrochemical industries, / any other large industry. ONGC informed that the offers of Assam drilling has been evaluated technically not acceptable as some of their submitted experience documents did not comply with the BEC requirement. As per BEC, bidders are required to submit work orders of similar service having amount of 2.01 crores. However, as per ONGC, Assam drilling has submitted work orders which are not in conformity with BEC requirement of 130 crores only. Assam Drilling emphasized that they have submitted 5 work orders amounting to more than 75 lakhs for fabrication of water treatment plants issued by IIT Guwahati, which have not been considered by ONGC. ONGC countered that the work orders for fabrication of water treatment plants issued by IIT have not been considered as educational institutions, does not fall under the ambit of the industry. So this was the opinion of the Technical Evaluation Committee of ONGC. That educational institution does not fall under the ambit of industry. We noted that ONGC has not considered work orders issued by IIT Guwahati. However, as per BEC, fabrication experience in any large industries is acceptable. Phase, any other large industry stipulated in BEC is very generic, which covers educational sectors industries. If ONGC intended to restrict the qualifying experience of specific industries, then the BEC should have been framed accordingly. In our view, experience in educational industry may be considered acceptable as per the BEC clause of subtender. However, we advise ONGC to review evaluation of offer of Assam drilling regarding non-submission of labor license or an undertaking for its submission. ONGC may seek it through clarification. Further, the opinion rendered by IEM is advisory in nature of IEM shall not be made responsible in any legal proceedings in line of the instructions issued by CBC. So the opinion is, the IEM opinion is not binding on nature and have part of the opinion being shared in the interest of transparency. So they have what they have said that ONGC should have considered their case. Now, while deliberation, Lordship, we have come to know that this Assam drilling, although had worked in PHE on the basis of some work orders issued by IIT Guwahati, and the work is not relating to IIT Guwahati. During the deliberations also, and that was a part of the record in the deliberation before IEM also, that their work was relating to public health engineering, water treatment plants in Boku. That is why I made a submission the other day that I will produce the record that where the work was actually executed. That was the record which we intended because we volunteered to submit the records for this honorable court's perusal. To that effect, we have filed the affidavit by annexing the relevant documents. I will come to that a little bit later. But why? Now, the learned senior counsel for the petitioner is saying that we have not taken a decision. We have taken a decision, we don't have record. Sorry. So, we have not taken a decision and there is no minutes of that we have produced. If Lordship is pleased to look at the order dated 9/5.
Of this court.
12/5. 9/12/2024. Yes. That order is on the prayer of the parties, list the matter on 2012-2024. On the said date, the ONGC shall inform this court as to whether the recommendations made by the IEM, which I have just placed, with regard to a relook of the respondent number 5 technical bid is going to be accepted or not. So there is a direction from this honorable court to take a decision. We have taken a decision and we have put it in on affidavit. Now, if my learned friend insists that we should have a proper minute, that will have a more value, more strength, rather than an affidavit on oath before this honorable court, then I have no reply. In our affidavit, we have put it in very clear terms.
Where's your affidavit?
That affidavit, Lord. I'll just.
Recent one?
No, not the recent one, the earlier one. Lordship will kindly come to page 137.
The second one.
137, the clause title. An additional affidavit by the respondent number 1 to 4 in compliance of order dated 9/12/2024, which I have just read out, of this honorable court to intimate as to the stand of the respondent number 1 to 4 with regard to the recommendations made by IEM. Lordship will now kindly come to paragraph 3, page 139.
Yes.
May I read it? The answering deponent begs to state that with regard to the opinion of the IEM, that large industries means oil field installations, rig, etc., or any other large industries stipulated in BEC is very generic, which covers educational sectors / industries. In our view, experience in educational industries may be considered acceptable as per the BEC clause of the subject tender. It is stated herein that even though the bid of respondent number 5 was initially rejected by the answering respondent, and the same was rejected by the respondent number 5 by email dated 29/4/2024. But thereupon, after the opinion provided by the IEM on the said subject matter of rejection of the bid of respondent number 5, and after the deliberations held in the meeting with IEM, an in-house discussion was held in ONGC, reassessing all the factors, and it was understood that the phrase any other large industry stipulated in the BEC is very generic. Also, it was seen that in the response to the query raised by Ahmed repairing works, types of few industries were mentioned with the term etc., and the use of this term has broadened the definition of large industries, and even educational sectors could be accommodated within it. As a result, any contractor having experience in sectors other than oil field installations, chemical industries, petrochemical industries would also have been participated in the tender. Therefore, keeping these points in view, the opinion of the respondent number 1 to 4 is to consider the offer of respondent number 5 for further evaluation, which shall resultantly increase competition in the tender. So in very categorical and specific terms, we have informed this honorable court through an affidavit. Now, if some office notice required, then Lordship, we may have, we may not have. We do not, that was not considered as important in the earlier round. What was important is that whether initially why ONGC have rejected. ONGC have initially rejected because they considered that it is an educational institution. But during the deliberations before the IEM also, it has come to the notice that the work is not relating to IIT Guwahati. IIT Guwahati was just a nodal agency who was conducting this work for PHE. That affidavit which we have lastly filed contains all the documents, Lordship, which Lord, page 166. Yeah. Paragraph 2, I would like to read out. 167. Paragraph, page 167. The respondent begs to state that during the course of hearing of the instant petition on 17 to 25, it was argued on behalf of the respondent that even though the respondent deponents at the onset rejected the techno-commercial bid of the respondent number 5, considering the fact that the work orders submitted by the respondent number 5 were placed by IIT Guwahati, and as such the same could not be considered and thereby does not fulfill the bid evaluation criteria. But upon perusal of the said purchase orders and the work completion certificates, it is apparent that even though the purchase orders were issued by Research and Development / IIT Guwahati, but the said work was tied up with PHE Department, Government of Assam. All the jobs that were executed relating to the purchase orders were executed at various subdivisions of PHE, Boko, and Sangsari. Therefore, it is now clear that the end user of the said rejected purchase orders was of PHAD, that is Public Health Engineering Department, which is one of the major department under the Government of Assam. So this annexer A, B, C, D, Lordship will kindly come to page 172. This is what we intended to place before this honorable court for perusal. So IIT Guwahati issued this at the top, Research and Development Department. Because of the technical expertise, they were taken on board. Work is fabrication of 40,000 LPD water treatment, make fabricated items, etc. Description of the item, Lordship will see. The valuation is there. And where it has to be done. Then these are all identical documents, more or less, Lordship, and the completion certificate, Lordship will find 184. The fabrication of 40,000, etc., fabrication of acrylic work, fabrication of aerator assembly, etc. MS Assam Drilling Fields and Equipment Services has fabricated the above mentioned water treatment plants and its accessories and successfully deployed on the same on 12/9/12/2021 at Sangsari PHE, Guwahati. Their performance was found to be satisfactory. Issued by the authorities competent, that is Professor of the Chemical Engineering, IIT. The next is, Lordship, that first work is in Sangsari. Then second, page 185. Same paragraph, last one. Assam Drilling and so and so. And is existing water supply at PHE Boko 3. So that is Guwahati, Boko. Another area in the district of Kamrup. And third one, page 186, PHE Boko 2. Then fourth one, PHE Boko number 1. So all these works were issued by IIT, and the work execution was at Public Health Engineering Department in its various projects. And during the course of hearing, I would like to place page 188 also. Opinion of the independent external monitors, representation from Assam Drilling, where they have submitted these documents at page 190, serial number 5, down below. Assam Drilling stated that the work executed under serial number 5, 6, 7, 8, and 9 are supply and installation of fabrication of water treatment plants. POs were issued, that is purchase orders were issued by the Research and Development Division of IIT Guwahati, which is one of the most reputed and largest in the educational industry of the country. It has tied up with PHE to design water treatment plants for chemical-free treatment of water to be used for human consumption. All the fabrication and painting jobs were executed at various subdivisions of PHE Boko Guwahati and Sangsari Guwahati. These are divisions. The same has been clearly mentioned in the completion certificate. The end user PHE is one of the major departments of Government of Assam, and its main work is to plan and implement water-related schemes at grassroots levels. Its works involves extraction of groundwater by boring wells, treating and distributing for human consumption, it operates under water industry, which is a large industry in itself. Assam Drilling has stated that the works falls under the fabrication and painting of fluid tanks on at any large industry as per BAC clause. So these facts were there before the IEC also, IEM. So my humble submission is that if only the minutes of the committee which assess the techno-commercial bids, there should be minutes, then Lordship, that decision was not taken at that point of time, when the Honorable Court passed a specific direction. They have an in-house discussion. It was not minuted. If Lordship directs, we can do that, but that will be a mere formality. But that formality is not important in the decision making. When a decision has been taken and on affidavit and on oath, we have submitted before this Honorable Court that we have discussed in terms of the order passed by this Honorable Court on 9th of December 2024. And before 28th of December, we have filed the affidavit saying that as per the direction of this Honorable Court, we have said all together who are at the helm of affairs, we have come to the conclusion that IAM's opinion we are going to accept. We have done a mistake at the earlier process. Now we are rectifying. If we do not do, Lordship, he will become the writ petitioner and my friend will become the respondent.
User cannot file, Lordship. User cannot file. There's a bar.
Because if we still keep him out of the race of this tender process, he will have a right, because apparently we have realized that a mistake has been committed on our part. All the facts are before this Honorable Court. That whether any other large industries will also include educational industry as well as the public health engineering industry relating to water. So these are all major work departments, number one. Number two, what is the work? The work is painting, refurbishing, and fabrication. This work can be done in any other industries also. My learned friend is rightly saying that drilling will become some volatile situation may evolve, but that precaution is required in every situation. They are not into that technical part, because some equipments, if they have to, what they have to do, they have to do the painting works or the welding part. So everything has to be done. And there are other agencies which look up after the safety measures. There are specific agencies, even the writ petitioners also. Their work will also be monitored. If I get the work, if I means the other party gets the work, they will do. Now we are doing it. ONGC on its own are doing it. Because this tender, we could not proceed. Then we floated another tender, because this tender period was 3 years. Then, because there was a stay order of this Honorable Court, so we could not proceed. So as a stopgap arrangement, we floated another tender to allow us to go for a stopgap arrangement for 7 months. That is also not getting the green signal of the Honorable Court. So now my humble submission is that this writ petition, we have placed all the records. If any other record is required, that minutes we have not done. If Lordship allows, then we can do it, but that will be a mere formula that there is no requirement. On affidavit, we have submitted, and we are not going to take back our decision also. And till now, the commercial bid, the financial bid are not open. What is the main area? The area is that he does not, the writ petitioner does not want the private respondent to participate in the competition. If he comes, then the competition will be wider. We do not know what value who have quoted. So at that stage, we are all stuck. So nobody will be prejudiced. He wants a walkover. That is the problem. He does not want any competition. And we are depriving him on a wrong assessment. Our decision-making process, our decision was faulty, and which we have admitted and coming and before very clearly we are expressing before this Honorable Court. And we have a reason also. IAM expressed it, and after that also we have verified all the documents. He worked, actually his work was related to Public Health Engineering Department. Even suppose in IIT Guwahati also, there are huge installations in IIT Guwahati also. If we have done this general work there, repairing, fabrication and painting, these are the works. This can be done in Guwahati High Court also, Brahmaputra Ashok Hotel also, anywhere. The value should be there, that 2 crores. So 75 crores we have not considered because his work was relating to IIT Guwahati as per our initial thought process. Our initial assessment was totally based on incorrect factual premises. We thought that they had worked, but even that, if suppose now we have come to know that he has actually worked in IIT Guwahati, then also any other large industries will include that industry. Because IEM also expressed his view that in the educational industry is also a major industry. So this is my humble submission. Already we are suffering. It's a public project, Lordship. And these are major work which can have adverse effect in the ongoing drilling processes. So in that view of the matter, in my humble submission, Lordship may be pleased to dismiss this petition by considering the affidavit and allow us to proceed and complete the whole tender process at the earliest possible time. This is my humble submission. My friends may be arguing. So from our side, it is over.
You have respondent number?
5.
And this respondent number 5, whose technical bit is now going to be accepted because
You are assisted by?
by
Yes.
I'll take the Lordship first straightway to the writ petition. Lordship may kindly see page 45. I'm sorry, before that, page 42. And my learned friend, Mr. Saikia, senior counsel, has already submitted that. Earlier, our technical bit was rejected by not taking into consideration the job we have performed in the IIT Guwahati. If the job we have performed in IIT Guwahati is taken into consideration, then I fulfill the criteria mentioned in the NIT. That is the whole case matter. Now, your Lordship will kindly see, after this, IEM has given an opinion at page 39, which your Lordship has already read. My learned friend, Mr. Saikia, has already pointed out what is the opinion of the IEM. Opinion is at page 39. Page 39, where the opinion starts. Page 40, Lordship may kindly see. Page 40, the second paragraph, we noted that ONGC has not considered work orders placed by IIT Guwahati. However, as per BEC, fabrication experience in any large industry is acceptable. Phrase any other large industry stipulated in BEC is very generic, which covers education sector, industries. If ONGC intended to restrict the qualifying experience to specific industries, then the BEC should have been framed accordingly. In our view, this is the view, madam. In our view, experience in education industries may be considered acceptable as per the BEC clause of subject tender. Therefore, we advise ONGC to review evaluation offer of Assam drilling, that is respondent number 5, madam. Regarding non-submission of labor license, that is a different thing, madam. Now, this was the view of the IEM. Now, Lordship will kindly see at page 42. After this view was given by the IEM, the writ petitioner submitted a representation to the authority, and they, I'm sorry, madam, the yes, writ petitioner. That is of 9th of June 2024. There they have indicated everything. They are again trying to distinguish, and they are trying to say the job we have performed in the IIT Guwahati should not be taken into consideration. They have given their own views for that. But they have basically by this representation submitted that the view given by the IEM should not be accepted. Now, page 45, annexure 8 is the document to which the ONGC has responded, my lord, on the representation. To Raju Ali Segar, dear sir, your representation to the independent external monitors against subject tender was examined by the IEM. The operative part of the opinion reads as under. Having heard Raju Ali and ONGC, our opinion is under. So the phrase any other large industry stipulated in BEC is quite broad and generic. Prior to tender submission, ONGC had clarified definition of large industries as large industry means oil, field installations, rigs, drilling, work over, chemical industries, petrochemical industries, etc. The word etc. is there. This clarification was explanatory in nature and did not alter the intent of BEC. The use of etc. in the clarification allows inclusion of other relevant industries. Further, no amendment to these experience criteria stipulated in BEC was issued. Therefore, offers are still to be evaluated as per BEC stipulated in tenders. In view of this, we find no merit in this representation and uphold our previous opinion rendered in the case of Assam drilling. So this document is the rejection of the representation saying that please don't accept the view or change the view. This rejection, which says clearly in view of this, we find no merit, is not under challenge in the writ petition. I am raising first objection to the maintainability of the writ petition because when this document says this, possibly this is the communication of the decision of the IEM. IEM has taken the decision that our opinion is correct. You have represented against our opinion. We say that our opinion is correct. This they should have challenged before challenging the further action to be taken by the ONGC. Based on this, they should have challenged this, saying that no, this is not a correct view. This was not challenged. Also, may kindly go to the prayer, madam.
I'm not telling.
No.
Specifically, I'm not.
Yes.
Don't
Page 21, they have not challenged it. It's not under challenge. So that is my first submission that the writ petition will not be maintainable without challenging this. Secondly, my lord, I'll not elaborate much. I'll just indicate. Lordship may kindly have a look once again to page 24 of the writ petition, where 24. That is the invitation to the bid, my lord. In other words, the NIT, my lord.
Yeah.
My lord, serial number 3 is the brief description of the work for which this tender is floated. Fabrication works, painting of rigs and equipment, and bunkhouse repairing for a period of 3 years. And what is the nature of the job? That has to be seen. The whole dispute here is the nature of job which the ONGC wants through this NIT to be executed by a third person. According to the petitioner, this job cannot be performed by the respondent number 5. Now, what is the job? Fabrication works. It's not that in an industry of chemical industry, we have to do something, some technical job. It's not that. It's a simple thing of fabrication. Fabrication work and painting of rigs and equipment. So job is not a very technical job. And that is why similar kind of job we have performed under the IIT Guwahati for the different departments of the government of Assam, which were ultimately taken into consideration by the ONGC to hold that no, they can perform it, and we will take into consideration the job executed by respondent number 5 in IIT. This is the thing, madam. So in view of this, madam, my submission will be, if the job is not a very technical one, but of the nature of fabrication and painting, etc., if this job we have done in any other place, that has to be taken into consideration. And initially, ONGC, when rejected our technical bid holding that this cannot be taken into consideration, they are very open and clearly in their affidavit and in the oral submission of the learned counsel appearing for them, they have made it clear that earlier we were wrong. we proceeded on a wrong premise, saying that they cannot perform it and their work performed in the IIT Guwahati cannot be taken into consideration. Now we are changing our decision, and they are changing their decision not on the basis of any arbitrary action, my lord. They are changing their decision because the IEM, which is an expert body, they have now said that no, it has to be taken into consideration. Now, next I'll show, my lord, what is the power of IEM. Writ petitioner is saying that I cannot give such opinion. My lordship will have to see what is the power of IEM. For that, my lord, lordship will kindly turn to our affidavit where we have annexed the standard operating procedure for implementation of this integrity pact. That is available at page 63, my lord. Both the writ petitioner and the ONGC are, my lordship has got page 63. Page 63, my lord, is the circular number so adoption of implementation of the Integrity Pact revised standard operating procedure regarding the commission. The commission has reviewed the standard operating procedure for adoption of Integrity Pact IP by all government organizations, public sector enterprises, public sector banks, insurance companies, and other financial institutions, and autonomous bodies, etc. A copy of this revised SOP is enclosed. Now, next page is the revised SOP, my lord. Lordship, may kindly see 1.1. What is the purpose of having this integrity pact, madam? In order to ensure transparency, equity, and competitiveness in public procurement, the Commission recommends adoption and implementation of the concept of Integrity Pact IP by government organizations, public sector enterprises, public sector banks, etc., etc. Now, down below, my lord, Integrity Pact, under the heading Integrity Pact, Lord will find page point number 2.1. The pact essentially envisages an agreement between the prospective vendors, bidders, and the buyer, committing the persons, officials of both sides not to resort to any corrupt practice in any aspect, stage of the contract. Only those vendors or bidders who commit themselves to such a pact with a buyer would be considered competent to participate in the bidding process. In other words, entering into this pact would be a preliminary qualification. The essential ingredients of the pact include. Now, lordship will kindly turn to the next page, and 2.4 is the relevant point. 2.4, I am reading at page 66. Integrity Pact in respect of a particular contract shall be operative from the date IP is signed by both the parties. IEMs shall examine all the representations, grievances, complaints received by them from the bidders or their authorized representative related to any discrimination on account of lack of fair play in modes of procurement and bidding systems, tendering method, eligibility conditions, and this is very important, eligibility conditions, bid evaluation criteria, commercial terms and conditions, choice of technology, specification, etc. So this IEM has the authority to enter into every aspect of the bidding process, including the eligibility conditions. Here we are concerned with the eligibility conditions. Now, 2.6, my lord. The role of IEM is advisory and not binding. And advice of IEM is non-binding on the organization. However, as IEMs are invariably persons with rich experience who have retired as senior functionaries of the government, their advice would help in proper implementation of the IEM. So, my lord, this is the position of the IEM and the view expressed by the IEM. It is clearly said it is not binding. The discretion lies with the ONGC whether to accept or not to accept. Now, they have shown in their affidavit their own reasons for accepting this view and changing their decision. That earlier we rejected your technical bid, but we are now taking into consideration the work you have executed in the IIT Guwahati. And if we take into consideration that, you come within the zone of consideration and you become responsive in the technical bid. Financial bid is yet to be opened, and the field of competition will be large. The authority will be in a position to choose a better entity for execution of their work. And now when the opinion has been given, the ONGC by filing an affidavit said that no, we are changing our decision. We will accept the work they have performed in the IIT Guwahati, and they will be qualified in the technical bid. And further process of the tender will go on. Now at this stage, repetition is filed saying that no, you cannot accept that opinion. Now they are saying that technical bid submitted by me should be rejected. The prayer is what, my lord? Lordship may kindly have a look. Prayer is that respondent authorities not to reconsider the techno-commercial bid of respondent number 5. ONGC has given their own reason for which they are accepting now the view expressed by the IEM. And although SOP says that the opinion given by IEM is not binding, they have got their own discretion, and they have exercised their discretion by giving valid reasons, producing documents to ensure that there is transparency, there is correct interpretation of the terms of invitation. Even before this dispute arose, at page 33 of the petition, what we will find at in the possibly pre-bid stage, some clarifications were given by the ONGC at page 33, my lord. After the serial number 1 and 2 in between, my lord. The experience of both the parties is required. Large industry means oil field installations, rigs, drilling, workover, chemical industries, petrochemical industries, etc. Now, this was there even before. And now they want to say that job performed in IIT Guwahati will have to be taken into consideration. Now, the interpretation given by ONGC in their own document, that is the invitation to bid at page 24, in my humble submission cannot be questioned, because the Supreme Court has very clearly said that the interpretation of the terms of invitation is with the author. ONGC is the author. They have interpreted this, my lord, terms of invitation, and they are entitled to give their own interpretation. And the Supreme Court has said the high courts will be very slow in interfering with such interpretation given by the employer. And for that matter, I am relying on a decision. This is relying on those FCONs, etc., my lord. 2022, volume 5, SCC, page 362. Page para 26, man. Para 26 at page 384, man. And para 30, where FCON's infrastructure was relied on. Para 26, man, says, the above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirements. And if its interpretation is manifestly in consonance with the language of tender document or subserving the purchase of the tender, the court would prefer to keep restraint. Further to that, the technical evaluation or comparison by the court is impermissible And even if the interpretation given to the tender document by person inviting tender offers is not as such acceptable to the constitutional court, that by itself would not be a reason for interfering with the interpretation given. Then para 30, my lord. It has also rightly been pointed out by the appellants with reference to the decision in F1's infrastructure as extracted in the quotation herein above, that an interpretation by owner or employer of a project to the tender document may not be acceptable to the constitutional courts, but that by itself would not be a reason for interfering with the interpretation given. In the aforesaid view of the matter, the long-term exercise of the High Court on dictionary meaning of the words and on semantics, in our view, had been entirely unnecessary. So my submission before your lordship, here in this case, we are concerned with the interpretation to the terms of invitation regarding the nature of work to be performed given by the ONGC, that too, my lord, on the basis of a view given by the IEM. May not be, my lord, interfere with by this honorable court, because the honorable Supreme Court has said constitutional courts will be very slow in interfering with this kind of interpretation. That being the position, my lord, the petition is liable to be dismissed, and the ONGC authority may be directed to proceed further with the tender process and finalize it.
Lordship, I'll give a reply at 2 o'clock.
Can I make a mention, Milord? Item number 28, Milord. Can I have it after 2 weeks, Milord? 28. Okay. On request made by Mr. Let's go to the Milord. The consequent list of the 2 weeks.
Lordship, we would like to mention an item for listing lordship today. Bless. We have been,
Mention hours at 10:30.
Lordship, I know, Lordship, but we have been able to file it after some time. That's why I couldn't mention in the morning, and Lordship, there is very urgency.
What urgency is there?
Lordship, we have been operating a bonded warehouse since 1988. Yesterday, we have been served a notice that we have not mentioned some certain area square feet in the trade license, and that's why it should be closed within 24 hours. So today is the day. If the matter will not be taken up or tomorrow, Lordship, then they will seal the premise, Lordship.
Tomorrow
morning, Lordship.
May please, your Lordship. Lordship, a number of things have Number of things have been said. Primarily, they say that they took a decision, but they do not have the records. That is the most glaring point which they have made. And another point which they say they have taken the decision after the order of the court, of this honorable court. That is incorrect. I'll just point to your lordship. A state cannot take such a major decision whether to include another person into a tender after you have decided and rejected without there being a minute. And the affidavit is totally silent as to who took the decision, Lordship. Whether it was the clerk, someone who supervised the field, the peon, I do not know. Even the clerk of ONGC belongs to ONGC. Affidavit is absolutely silent. And Lordship, under those circumstances, can they be permitted to improve the case now? First, I'll come on regarding the meeting, Lordship. This Lordship will find that I filed my writ petition. I filed my writ petition sometime in June. The stay order was given on 27/6/2024, where the stay order was given. It will not consider the technical bit of the respond number 5, specific stay order. Then Lordship, they filed their affidavit for the first time on 11/11/2022. In that affidavit.
Who filed the affidavit?
The ONGC. In the
interim order is?
Interim order is 27/6/2024. They filed the affidavit after a couple of months, few months, on 11/11/2020. 24. And what did they say in the affidavit, Lordship? Lordship will come to page 118. Page 118, paragraph 9.
Yeah.
That with regard to the statement made in paragraph 14 of the, that on 1/5/2024, the respondent number 5 preferred the representation to the answering deponent is admitted admitted upon, since the same is a matter of record. But with regard to the rest of the averments made in paragraph 14, the answering deponent begs to clarify that even though ONGC initially considered that any education institution like IIT does not fall under the ambit of industry, and it would not be appropriate to refer to the education sector as an education industry. After deliberation was held in the meeting with the IEM, an in-house discussion was held. Now again, Lordship will come. An in-house discussion was held. And ONGC reassessed all the factors, and it understood that the phrase any other large industry stipulated in the BEC is very generic, and even education sector can be accommodated with it. It was therefore, any contractor having experience in any other section other than oil field installations, chemical, etc., could also have participated in the tender and the work submitted by the respondent number 5 in connection with the works in service related to Guwahati IIT falls within the ambit of large industry. So immediately thereafter, they took this decision. They had in-house, but my notes, I'm sorry, Lordship, they do not have. We do not know who has taken. Not even, nothing. Then Lordship will come. What has happened on 18, then this Honorable Court passed an order on 9/12/2024. 9/12/2024, which they asked the ONGC to have a relook and let the court know what it intends to do. Then they filed an additional affidavit again on 18/12/2024. That is again at page. Oh. Where is it? Which affidavit are you giving me? Their affidavit, ONGC affidavit. Additional affidavit. Yes. They filed an affidavit where they admit that is again at something messing up. On 11th of page 137, 18th of December, they filed the same thing at page 140. Lordship will find from paragraph 4th line. Thereafter, after the opinion provided by IAM on the subject, the matter of rejection of the bid of respondent number 5 and the deliberations held in the meeting with the IAM, an in-house discussion was held in ONGC, reassessed all the factors and understood that the phrase any other, this the same thing. So this decision was taken way back, Lordship, before the first affidavit was filed. Now they say pursuant to this Honorable Court order is not correct. It was taken before this Honorable Court's order was passed. But be that as it may, where is the minute, Lordship? We do not know who has taken the decision. ONGC has taken the decision would not suffice. There has to be a decision-making process, which the Honorable Court will look into and find whether the decision-making process has been done correctly. But it is admitted now, there's no minuted decision. So there's no records. In absence of such records, can your Lordship allow this decision to stand? It goes against all canons of law, fair play, justice, everything. It's unheard of in administrative law. It's something that is totally unheard of. In view of this, in this score, I mean, I don't even have to go to the rest of my points. In view of this itself, the opinion which they formed, I don't know on which day, I don't know over when and how and with whom they discussed, that has to go. It's only on affidavit they have said, and that also they do not specify who has said, who took the decision, who was present in the meeting. And now even a suggestion has been made that if your lordship wants, we can have a minute. Lordship, is that done? That is something unheard of, lordship. I mean, it's really a blot in fair and good administration. That lordship cannot permit to happen. Where will we head if this happens, lordship? The state will be in utter chaos and nothing else. Now, lordship, on this score, it should go. Now, Mr. Majumdar has raised another thing that I have not challenged the question, the opinion of IEM. I don't have to challenge the opinion. IEM themselves say that my opinion is only advisory, and I am outside, and even the integrity, the commission notification under which the IEM has been filed, they said they will not be liable to any kind of correction by the court, if I may be put it like that, because they give an advisory body. And what is the purpose of the IEM? IEM has been constituted under the Central Vigilance Commission. Sole purpose is implementation of the Integrity Pact. And lordship, in the instruction to the bidders also, at clause 38, it says, there's a note, 38.2, there's a note. IEMs would consider only those representations on post-contract issues where there has been an alleged violation of the provisions of the IE. So reading from the page number 24. Oh, page number 24. What are you talking about? I'm reading from this document.
38.2.
This instruction, 38.2. 38.2. There's a note, IEMs would only consider those representations, and otherwise also, Mr. Majumdar has fairly pointed out that it is only the author of the tender document who can interpret a clause of the tender. I had also placed my decisions on that. It's very fairly, but now who's the author in this? It's the material management of ONGC who is the author. So I am not, even the courts can't interpret. So who is IIM? IIM is no one. So the interpretation has to be left to the authority the way the author understands. In this case, the IEM has taken over the power, the right of the authority to say what it means by this. And even in this honorable court, it's the drilling department who has filed the affidavit, not the materials management. The author has not come. Author has been kept at home sleeping. Now IAM comes, IAM takes over to interpret a clause which it has no business to do, as held by the Supreme Court, and my learned friend has clearly pointed out that. That apart, Lordship, if that is the case, I would give, and there's one more aspect which comes by this decision of the so-called decision, backed without materials on record, to induct in respond number 5. Now, if the ONGC had clearly taken a reasoned, instructed, informed decision, that yes, IIM has said that I think meetings recorded, proceedings properly drawn up, and taken this decision to expand the scope, I cannot question. They have the power to cancel. In that event, they'll have to retender. That is, again, I'll place the Supreme Court decision there. There's again a decision of the Supreme Court. He says that you can do that, but you have to retender, because why? By enlarging the scope of the tender, you have now made it open also to other people who have done maybe water supply work. They have done this is the denial of participation, privilege of participation, which is a very important. By expanding the scope, inducting respondent number 5 alone, and not opening out to others who are similarly placed. Apart from Ramanna Lordship, which Ramanna says very clear, 2016 8 SCC, page 622, Central Coalfields also clearly says that the denial of privilege of participation cannot be allowed in administrative law. And plus, Lordship, another thing. During the tender process, the goalpost cannot be changed. The goalpost was this, what the ONGC understood at the first step before IM came into force, play. That was a goalpost. Now with the IM coming, they've changed the goal. Shifting of goalposts cannot be permitted. That again is stated by the Supreme Court in 2016 8 SCC, page 622. Lordship, these are the reasons, and now even in the materials which they have taken, Lordship, final affidavit which they filed, there I find they have annexed of order copies which they have now accepted after expanding the scope. Lordship will find they've annexed this now from page 172, annexure A. Lordship, that is a supply order. Annexure A is a supply order. They want 1 unit of 7,000 of 40,000 LPD water treatment plant, 1 unit. They want it to be fabricated. That is valued at this. It is quantity is 1. And please arrange supply. It's a supply order, Lordship. Not that fabrication, you go and do fabrication. No, it's not that. That is a clearly supply order, which they have 45 days from the date of receipt. And the supply is to be made at a place fixed by them. Then Lordship will come to, where's my note? But no, the one you made. Then Lordship, 2 is also this, B is also the same. No, that's completion. So this B is acrylic sheets make, mode fabricator. This is again a supply order. This is also a supply order, Lordship. Only in 2 places these are annexure B is also a supply order. And annexure C is supply and installation. Probably that's some work. Annexure C is supply and installation. So A and B is not applicable there. Then again, Lordship will come to annexure D. This is D is supply and installation. Lordship, I will not. They have, I think they hold retrospecting to be there. Let them hold. That's okay. And I will not ask your Lordship to go into such intricate details. But where there are supply orders, now they want a 40,000 liter LPG water tank, water plant. They have to fabricate and supply. That is not that's a supply order. That is not fabrication, drilling, etc., painting. Sorry, let's not that clearly it says supply order. But even that apart. And then Lordship, what they have done, they have also taken one more to give the number of years. They have also taken one more item accepted. Lordship will come at page. I have written in my affidavit, they have not responded. Indeed. Yes, Lordship will come to page 194. Item number 10, repair maintenance of 16 numbers of cementing equipment of ONGC Najira. Lordship, this is a manpower contract. This is not a fabrication. This is a manpower contract only. I have stated in my affidavit in reply. So this cannot be, this they have brought in to show that 3 years. And we read that as it may, Your Lordship. My main point is that they do not have any records on that score itself. And it's admitted position. And the affidavit does not say who takes the decision. The author of the document, of the tender document, is out of the scene. IAM cannot interpret. And if these supply orders go, they don't even qualify for 2 crores. But Lordship, such details, Lordship will not look into. Lordship will look into only decision-making process. They cannot change. If they change, they have to cancel. But they cannot waive. That is 2010, 6 SCC, page 303. Do you not have this? Lordship, they cannot change. They can change, but if they change, they have to cancel the bid and they have to retender. That is very good. Paragraph 64. I think I've given your Lordship a copy. 2010 6 SCC. It is true that the state or a tendering authority is bound to give effect to the essential conditions of the eligibilities stated in the tender document, and it is not entitled to waive such conditions. Page 6, paragraph 64. Paragraph 6, this is very clear. They have waived, they've expanded the scope, their own affidavit on oath. It is true that the state or its tendering authority is bound to give effect to the essential conditions of the eligibility stated in the tender document and is not entitled to waive such condition. But that does not take the right away its right, administrative discretion, to cancel the entire tender and proceed in public interest, provided such action is not actuated with ulterior motive or otherwise not vitiated by any vice of arbitrariness or irrationality or violative of some statutory provisions. It is always open to give effect to new policy it wished to pursue, keeping in view the overriding public interest and subject to the principle of Wednesbury reasonableness. So, Lordship, these are the things. Now you expend, and you just expend for one person. That is not possible. Paragraph 7, Ramanna case also comes in, Lordship. Because the privilege of participation has been denied to very many who would have been eligible. And Lordship, 2012, 7 SCC 200, no one can review, Lordship.
7 SCC?
Lordship, 2012 7 SCC. I've given those decisions. Para 26. This is what they have done a review also. At this stage, it would be apposite to observe that the power of review is a creature of the statute, and no court of quasi-judicial body or administrative authority can review its judgment or order or decision unless it's legally empowered to do so. So you cannot just review. If you review, you are again stuck by Lordship. Shimnitz case, that is what you have to do. Cancel, retender. I have nothing. You have your discretion. Lordship, I'll make a note of the decisions and I'll hand it over to your Lordship. I think that'll be more convenient. I'll do that, Lordship. By Monday.
Monday?
By Monday.
Will this on Monday?
No, Lordship, not
all
necessary. I
arguments
have finished.
All arguments are closed.
All arguments are
closed. Monday, you give your citation and then I'll close it on Monday.
Absolutely.
I think in item 60, there's a video request, petitioner's counsel was not heard, I think.
Item 60, none of us were heard. No one is heard, Lordship. Lordship, once this is done, 60 was actually to get rid of the,
Yes.
get rid of the stay order.
This petition will take care of the
60
other case.
others.
So
And
one Ganguly is there.
Yes, yes,
He was requesting for a BC.
yes.
I've allowed him, let's just wait for 2-3 minutes.
And Lordship, the absence of record is the death knell. My petition is not that score at all.
That I'll consider that part.
One small thing that I would like to please report it. That first of all, till now, there's been no decision as such. Because the moment the IM gave us their opinion, immediately preceding that, this petitions were filed. Therefore, Lordship, there has not been any decision as of now.
Opinion is.
We have been all along been stating that this is our opinion as of now, which we've formed. So there is no decision, Lordship.
So what about the statement in your affidavit?
That is an opinion, Lordship, which has been sought for by this honorable court. In an affidavit, there was a clarification. If Lordship perused paragraph 14 of the writ petition, it is basically where they have stated that why it was rejected. So considering the ambit of the large industries. So we just give an interpretation into that affidavit. That is with regard to our, this Lordship, if I may, it's paragraph 14 once. At Lordship page number 12, Lordship, 11. Of the writ petition, page 11 of the writ petition. Page 11. That on 1/5/2024, respondent number 5, Messrs. Assam Drilling Fluid and Equipment Services, total representation to the office of the CTM Head Oil and Natural Gas Corporation Limited, Nadira, Assam, against incorrect disqualification of its pay and providing the list of the work orders which was submitted by them in the bid document. Now, till that, as respect, Lordship, we have accepted and admitted the fact. It's a matter of record. The next part, Lordship, the works related to IIT Guwahati and services provided under contract number so and so was also added as a part of work experience, which does not fall within the meaning of large industry, as per bid evaluation criteria, as well as clarified by ONGC in its declaration. That was the statement which has been made in the writ petition. And to that effect, Lordship, we gave an explanation that thereafter, Lordship, once the IAM opinion also came, we saw that yes, large under the ambit of large industry, we can include even IIT. That was the statement. It was an opinion, Lordship. So we have never taken a decision as such, Lordship. As well, Anand Senior is stating that there has been a decision. No, there is no decision as well. We are waiting for the outcome of this petition.
Obviously, you can't take a decision.
Exactly.
There's a stay order.
So, since there is no decision, Lordship, there is no minutes of meeting to that effect.
Why? You can form an opinion, agree, and you don't have minutes of. This is ridiculous. Who took this opinion, Lordship? The clerk? The peon? Who?
Lordship, since the
This is
affidavit
a
has been
ridiculous statement which is made at the bar about the way the administration will. Ridiculous, Lordship. Any decision, any opinion formation, when the court has, especially when the court has asked, there has been discussion, there has been record, reasons given. To say no opinion and no decisions is taken and not to attribute responsibility is ridiculous.
This Lordship, the affidavit has been filed by the person who has been duly authorized by all the parties to this instant case.
What about para 9, page 118?
118, Lordship.
That's what I'm reading, madam. There, of course, since there is an interim order, they could not take any decision as such. My understanding is correct. They are only saying that after the deliberations held in a meeting with IEM, an in-house discussion was held in ONGC. ONGC means from the ONGC authority, not clerk. ONGC authority. Reassessing all the factors, and it was understood. They have only now understood that the phrase any other large industries stipulated in BC is very generic, and even education sector can be accommodated within it. Now, whether they will ultimately accept the opinion and whether his technical bid will be reconsidered, they are yet to take a decision subject to what the Lordship says, and in keeping in view that interim order was functioning or is in force till today.
Exactly, Lord.
And as far as the submission that there is an endeavor to expand the terms of invitation. In my humble submission, that is not correct, for the simple reason that this IEM's SOP itself is very clear, which is not under challenge. And in the SOP, my lord, para 2.4 at page 66, it is very clear what is the jurisdiction and function and power of IEM. It has been clearly said, I am again reiterating, my lord, integrated practice in respect of a particular contract shall be operative from the date IP is signed by both the parties. It is signed, page 66, my lord. Lordship is in my.
Yeah, that's
Para-
fine. Let us see para 3 of page 139.
Para 3 of page 1. In para 3, my lord, they have said the answer and dependent makes to state that with regard to the opinion of the IEM, that large industry means oil field installation, rigs, drilling workover, chemical industries, petrochemical industry, etc., or any other large industry stipulated in BSc is very generic, which covers education sector industries. In our view, experience in education industries may be considered acceptable as per the BSc clause of the subject matter. It be stated herein that even though the bit of the respondent 5 was initially rejected by the alternate respondent and the same was rejected by the respondent number 5 by email it is censored, but thereupon, after the opinion provided by IEM on the state subject matter of rejection of the bit of respondent 5, and after deliberations held in the meeting with IEM, an in-house discussion was held in the ONGC, reassessing all the factors, and it was understood that the phrase any other large industry stipulated in BEC is very generic. Also, it was seen that in the response to the query raised by Mr. Ahmed repairing works type of a few industries were mentioned along with term, etc. And the use of this term has broadened the definition of large industry, and even educational sector could be accommodated within it. As a result, any contractor having experience in sectors other than oil field installation, chemical industries, petrochemical industries, could also have participated in the tender. Therefore, keeping these points in view, the opinion of 1 to 4 is to consider offer of 5 for further evaluation, which shall resultantly increase competition in the tender.
You have already considered.
Madam, I have considered, but I could not take a final decision because I'm talking about ONGC. ONGC has considered.
You want to talk about
but
ONGC,
no, madam, I ultimately my stake is at.
No, Lordship, again, this affidavit has been filed in compliance to Order 912. There was a query raised by the Honorable Court that what will be your final stand, whether you'll go by the opinion of the IEM or not. That is what we have reflected in this affidavit.
In response to
We have
your
not taken a decision. We are saying our opinion now,
Yes, certainly.
considering the above discussion, considering the IEM.
I think this has been heard for a very long period of time.
I think we can
And
close
then-
now.
And it was, see, what you're saying is you have not taken a decision. Whether to permit respond, whether to consider respond number 5. Correct.
Lodge.
Now, where's the locus for the petitioner to file the writ petition?
Exactly. Lodge.
Have you taken that ground? No. And all this while we have been hearing for, I think for 2-3 weeks earlier also, released from
I'll
part,
give a small note, Lordship.
released from part, then came back to this court again.
Lordship, I'll
Not,
just,
not one day you've taken the ground that the
Because
petitioner has no locus.
the
But there
previous
is a-
not contained.
But possibly, so far as I am concerned, possibly there is a reason why this point was not taken. Initially, my lord, when the writ petition was filed, in the writ petition, there is no question of challenge of this opinion or
no, I
view of
didn't,
the
say- I
ONGC.
didn't say.
Exactly.
My lord, it transpired subsequently after your lordship passed an order.
And Lordship,
So initially, when the writ petition was filed, it was filed only with a grievance. That the interpretation now sought to be given with the help of the view given by IEM is beyond the terms of invitation. That is the only writ petition.
Exactly.
Nothing else.
No political spirit effect.
This
Lordship.
subsequent, my lord, subsequent view of the ONGC in response to your lordship's order, that what is your view? They have given a view that, see, according to us,
We should accept.
the job performed in IIT also comes within the ambit.
See, if that is the case,
Madam.
then the statement in this affidavit at page 140
40.
is what the learned senior counsel is submitting only, page 140.
140.
7 line from the bottom.
Yeah.
As a result.
Yes. Yes, madam. Last sentence. Therefore, I think therefore, or as a result, as a result, any contractor having experience in sectors other than oil field, chemical industries, petrochemical industries could also have participated in the tender.
That's what?
This is the query which was given to the Mrs. Ahmed. This is a statement which is reproduced. We said that considering all these points, if I may read Lordship once more. Also, it is seen that in the response to the query raised by Messrs. Ahmed preparing words, types of a few industries were mentioned along with the term etc. And the use of this term has broadened the definition of large industry, and even educational sector could be accommodated within it. As a result, any contractor having experience in sectors other than oil fields, chemical industry, so and so, could have participated in the tender. Therefore, keeping these points in view, because Lordship, the whole
No, what you are trying to say is, if the interpretation is taken,
Lordship,
then others also could have participated.
Absolutely.
Lordship,
Correct, but they did not participate because they did not have that, that the opinion was not there prior or when you issued the NIT. And therefore, those contractors who were willing to come, but they did not have that large scale, large industry, experience in large industry.
Absolutely.
They did not go.
Lordship,
So this is what you are saying.
because Lordship, that is not this case, Lordship.
Whatever is the case.
That is not the case here. The case here is the DSS.
It is not the case of the writ petitioner that, like my lord, we have in its report judgment, that if this condition was there earlier, others would have also have participated. That is not the case of the
That is,
writ
it's there,
Exactly,
it's
Lordship.
there,
This
It's
is not the
there.
case of the
petitioner
writ
is-
petition.
it's there.
writ petitioner is only saying that response number 5 should be excluded from the complaint.
Consideration.
Yes.
Exactly, Lordship.
It is not our case that I could have participated had this condition been relaxed in the way you are now saying. That is not the case of
Lordship,
it.
that's not the case. It's incorrect. Paragraph 22 of my writ petition.
Because you
The
are putting
petitioner
there in the-
states
Great.
that interpretation to the 22, page 18, the interpretation to the experience criteria is enlarged. Basing on the opinion of the IEM, it would amount to changing the entire bid evaluation criteria. And after the technical bid has been opened and in the midst of the bidding process, and it would be unfair to many others who would have been eligible to bid if this criteria would have been made known to them earlier. Specific statement I have made, Lordship. Specific statement is there.
Which paragraph?
Paragraph 22.
Raman,
Ramanna is there in my head. That's the first case we read in college. I made out this case right at the beginning.
my lord, it is, I'm again saying, my lord, it is one thing to say that by relaxing the conditions, now you are depriving others who wanted to participate. And it is another thing to say, as is stated in para 22, that you are expanding the scope so as to include response number 5. Our case is the second category, my lord.
Both.
That, no, how can we both? She is not, my lord, writ petition is not for others. It's not a PIL. It is for the writ petitioner only. What is the grievance of the writ petitioner? That you are now trying to include a person whose technical bid was already rejected. I think this is the case. It is not the case of the writ petitioner that, see, you are now going to relax the condition and thereby you are actually depriving those who could have participated with this relaxed condition. It is not the case of the writ petitioner, as was in Ramana Dayaram Setti matter. Here we are concerned with the grievance of the writ petitioner that in paragraph 22, the petitioners very clearly say that, see, by giving this interpretation to the terms of the invitation, you are expanding the scope so as to allow response number 5 to enter again, whose bid was already rejected. Now, here is a case, my lord, unlike other cases in the cases we have all cited, my lord. In those cases, there was no question of any opinion given by an authority like IEM. IEM gives a view that, see, it is case of, it's a requirement of fabrication and painting. Now, the response number 5, who has done similar nature of work in others, you are only saying that that is not an industry, that is not a chemical industry. Now the IM says, no, I have got authority under clause 2.4 of the SOP to interpret, to examine the terms of invitation. And I have interpreted, according to me, the work performed by the response number 5 in IIT Guwahati also can be taken into consideration because the term is a very generic one.
I'll consider those.
Reply, I'll not say anymore. I'll give a small note. I think there's no scope for reply to reply. I think he started. I'll give a small note on Monday or Wednesday. I'll just give a note, submit a note. Lordship may not.
Melody in item number. Ganguly is online.
Yes.
Item number 60, 59 and 60, Melody, they are related to item 58. It depends really on your lordship's
Yes,
decision in the first item.
Lordship may close it, my lord, as my learned friend Mr. Ganguly is saying that the fate of the second item, item 60, is dependent on the outcome of this first item.
60 is against the
take it-
subsequent tender, Melody, so
Yes.
that it all depends.
And I think
Lordship
Honorable
may
will not
close.
go ahead with this.
Yes.
Heard MS M. Hazarika and a senior counsel, assisted by MS.
Yes, no.
Learned counsel for the petitioner. Also heard Mr. D. Saikia, learned senior counsel,
MK Das.
assisted by M. Das, learned counsel for the respondents. 1, 2, 4.
1 to 4.
And Mr. D. Majumdar, learned senior counsel, assisted by Mr. A. Dhanuka for the respondent number 5. Just put also heard Mr. A. Ganguly,
Yes,
learned
ma'am.
counsel for the petitioner.
Right.
In item 60, WBC 5382 2024. You want it on Monday?
Wednesday, Lordship. I'll just submit
My
it.
lordship may, I think what my learned friend is saying is lordship may close it.
Close
but
it. I'll
my
just
learned
submit
friend
it. I'll
will
give it to
I
the,
don't want to close it. Let me get all those and I'll close it on with
As your lordship.
on Wednesday,
As
Lordship.
your lordship.
use the matter
Deep
again.
here.
What is Wednesday? 26.
Well,
If you're giving a note,
I'll give a note.
you can give it to them also.
Basically, decisions only I'll be giving Lordship to make it complete.
If you want to give your notes also. you
Yes,
can-
my always.
20 of daily list, admission.
One minute, 1 minute.
Yeah, please, your lordship.
1 minute.
Lordship,
Just get a copy of this also. But don't put it in this file. Give it to me here. Yes, please.
Lordship, my senior Mr. S.K. Medi has left the court due to some personal difficulties. So Lordship can, matter may be fixed on 28th of March.
28 is some difficulty is there.
Okay, then.
Lordship on 27th of March.
Okay, Lordship.
Heard, Mr.
A. Ghoshal on behalf of M. Bishwat.
Learned counsel appearing on behalf of Mr. M. Biswas, learned counsel for the petition on request made on behalf of S.K. Medi, learned. CJC,
Yes, Lord.
list on. When do you want?
27th, Lord.
21.
Maybe.
Matter pertains to non-payment of contractor's bill.
Water resources. Alright.
I think some time may be allowed, may. Most probably we have missed the item today, your lordship.
Okay, not much, 3,95,000.
Yes, your
Isn't
lordship.
that
Maybe
nice?
some instruction, some, your lordship.
It was filed as early as 2022.
Yes, your lordship.
Please,
Next week, your lordship.
let us finish it. Heard, Mr.
R.A. Chaudhary.
R.A. Chaudhary, learned counsel for the petitioner. On request made by MS
Ah, that-
R. Decker, and the standing counsel, Water Resources Department. When do you want? List the matter on 2nd April to enable her to receive instructions.
Obliged.
That day, let us try to see if we can finish it out. If this is
22.
immediate amount,
Yes,
we'll give you time, 3 weeks or 3 months, whatever.
yes.
Highly.
22, lordship, I have received instruction here, so it is, the work is under FMP scheme, your lordship.
Hmm?
Under flood management program, your lordship, and here, Lord, the major part has to be borne out by the central government, your lordship. Then, lordship, similar matter, this honorable court has fixed a similar series of similar matters on 2nd of April, your lordship. May I pray, lordship, this matter may also be take to WBC number 694 of 2025.
Okay, on request made by Ms. R. Decker and the standing counsel, Water Resources Department. List this matter on 2nd.
2nd of
2nd
April.
April. Along with WBC number
694 of 2025.
23,
23 also same.
You are appearing in item number
22, Lordship.
Hurt MS
F in this.
F in this, huh? That's on top. Okay. We are fixing it on second.
Lordship.
23 also same.
Admitted amount, my lord, only 1 lakh 32,723 admitted amount.
Same matter.
Same matter, your lordship.
Okay, Hurt Mr.
DK
Standard counsel for petition on request made by MS Swens, huh? This on second along with WBC. Same WBC.
Same age, your lordship. Second.
24,
I have the affidavit has to file. I have received the instruction. For 2 weeks, Lord. Also, date after 2 weeks.
Okay, Hurt Mr.
TK Mazumdar, my lord.
Standard counsel for the petition, Mr. Nobadia. Learned standing counsel irrigation department submits that he has received instructions and prays for 2 weeks time to file affidavit. Praise the Lord.
I have fixed date, maybe
Placed on
After Bihu, Lord.
after Bihu, 23rd April.
25,
Please, Your Lord.
Yes.
Lordship, in this case, we have received the instructions. I am being told that the written instructions are with Council P. Nair. Lordship, he'll be able to file the affidavit regarding this particular case.
Last date also time short and it was.
You are appearing for?
PWD, Lordship.
Okay, but Mr. S. Alim, learned counsel. Mr.
The P. Nair's name may be recorded,
P.
Lordship.
Nayak, learned standing counsel, PWD.
Lordship.
Submits that he has received instructions and prays for
2 weeks time, Lordship.
2 weeks time to file affidavit. Praise the Lord. It's after 2 weeks.
26,
May I please your lordship? As per order dated 4/12/2024, the respondent number 5 took 3 weeks time to file their affidavit, but till date they have not been filed.
Lordship, kindly allow 2 weeks time, Lordship. I will file affidavit, Lordship.
You have 4?
Respondent number 5, Lordship.
Okay, heard, Mr.
My lord, A.K. Hannan, a date may be given. And
A.K. Hannan, learned counsel for the petition. MS.
P. Odigari.
P. Adigari, learned counsel appearing for the respond number 5. Praise for?
Respondent number 5, Lord.
Oh, how much time?
2 weeks, Lordship.
1 week may be granted, my
Weeks
lord,
time to
because
file affidavit in office. Praise the Lord. List
a date
after
may be
2
fixed date.
2020.
On 28th of March.
That is 2 weeks.
No, Lordship.
Night.
You want to fix the date or I'll fix the date?
Fourth, my lord.
Are you going to fix the date or this court is going to fix the date?
This court.
22nd April.
27,
Malone, 27, they took time, my lord, to file instruction on the ground that they have already received instructions. My lord, no?
Lordship, we have received the instructions, but
Same prayer has been made today also, my lord. It is an admitted amount, lordship, for last.
Is it an admitted amount?
Yes, let them
the
say.
instructions are also not clear regarding.
Then, my
We
lord.
need proper instructions, Lordship.
I'll show your lordship from.
Then I'll give you as a last chance.
Lordship.
Okay.
Page 126, my lord, may kindly see. They have admitted, they have sent it for approval. Now they are saying nothing is clear.
Heard PG Ghosh, learned counsel for the petition. You are appearing on behalf of?
B. Gogoi in this case.
Mr. B. Gogol, and standing counsel PWD. Is allowed 2 weeks for the time to file.
Lordship may fix it within the March, my lord, so that I can
last
get
time.
something, my lord. It is 3 odd crores, my lord. I have
That will
taken
come
loan from the bank.
List on 2 weeks.
My lord, may on the 30th March or something like that. Let them say what they say, my lord. If they,
that will be difficult.
my humble submission is this, my lord. Instead of all detailed affidavit, let them obtain instruction whether it is admitted or not. On that basis, lordship may dispose of this matter.
You want
That,
to
that's
take
only, yes,
instructions
that
of
will
that
do.
affidavit?
We can obtain an instruction.
Yes, that will do, lordship.
But if it comes that we need to file a detailed.
Then it's a different issue. Let them obtain on a small instruction.
Okay, then you can say on request made on behalf of Mr. B. Gogoi, Leonard Standing Counsel PWD, list on 26th March.
To obtain instruction or the amount of the material. My lord, that's maybe the
Okay, that day if you get instructions, you come and see it. And then if you are filing affidavit, we'll give you time.
Yes, please. Obliged.
30,
The non-payment of contractual fee, my lord. This is also admitted amount, my lord. Page 14 is the completion certificate. no?
Affidavit has come? Yes.
Not yet.
My lord, earlier there was the different standing council. Now SR has been engaged as standing council of soil consumption. So we have that instruction, but within 7 days,
You'll file your affidavit. Who is appearing now?
now I am appearing for,
You're the standing counsel.
I'm on behalf of standing council SR.
SR Rabba. Okay. Standing counsel SR Rabba is what? BDC?
No, my lord, soil conservation department.
Huh?
Soil conservation department.
Okay, Soil Conservation Department. Okay. Heard Mr.
PK Mazumdar, my lord.
V.K. Mazumdar, Leonard Counsel for the petitioner. Mr.
P. Hazarika on
P. Hazarika, Leonard Counsel, appearing on behalf of Mr. S.R. Rabba, Leonard Standing Counsel, Soil Conservation Department, submits that they have received instructions and prays for 1 week time to file affidavit. Prayers allowed. List on third.
31,
Lordship, this is admitted amount, Lordship. Already they have filed affidavit, Lordship.
You file your affidavit?
Lordship.
Where is the affidavit?
Sorry, paragraph 4, Lord. Initially, the estimate was, Lordship, 1 crore 69 lakhs, later on, Lordship, it was revised, Lordship.
Lordship, page 48 will clear that.
1 minute. Non-availability of funds.
Lord.
Now, what is the position? It's the budget season, that's why I'm asking you.
Lordship, may I give him 6 months time to ask?
Okay. Heard, Mr. It's Sukadar, Leonard Counsel for the petition. Who is the work order?
Work order, Lordship, there are 3 work order. The initial was at page 20, Lordship.
Then?
Then at page 27 and 28.
These are separate work order or supplementary tender?
Supplementary work.
27?
And 28. 20, 27 and 28.
Okay. Also heard Mr. N. Obadia, Leonard Standing Counsel.
Irrigation, Lord.
Irrigation Department on behalf of all. No. 1 to 4.
1 to 4.
How about finance? As well as Mr. B. Gogol. B. Gogol, Standing Council Finance Department for the respond number 5. Stop. Para. Pursuant to attend notice dated 23/12/2013. The petitioner was issued a work order dated 28/2/2014 by the Chief Engineer, Irrigation Assam for construction of gated spillway at CH stop 16760 M of B3M canal with an estimated price of rupees 1,90,84,643. Stop. While the petitioner was doing the project work, the estimates were revised, and accordingly, a supplementary tender was also invited, in which the petitioner became the L1 bidder. And accordingly, he was awarded a supplementary work order, isn't it? Yes, Lordship.
Dated 21/1/2015 by the Chief Engineer, Irrigation Assam for construction of gated spillway at CH stop 16760M of B3M canal. Stop. For an estimated price of rupees 5,69,53485 458. Stop. While performing the project work, another additional protection work at the gated spillway at CH 16760 M of B3M canal was also awarded to the petitioner by a work order dated 2011/2017. Correct?
Correct.
By the Chief Engineer, Irrigation Assam for an estimated amount of nothing is here.
Lordship, the whole thereafter, Lordship, the
Okay.
revised estimate also prepared, Lordship, that at page 35, it is clear, Lordship.
Stop.
At page 31, Lordship. Revised estimate due to, Lordship, change of labor wages, material cost, etc., Lordship.
Accordingly, a revised estimate what
It's revised estimate, Lordship. Revised
was prepared amounting to rupees
total comprehensive estimate is 16 crores 19,6 lakhs 38,000.
for a comprehensive estimate of rupees 16,96, 38,080.36. Correct?
Yes, Lordship.
No, but in the bottom, additional financial involvement.
Means 4 crore 76 lakh.
Stop. Anyway. No, your total estimate value of your work was 11 crore, isn't that? 11 crore 03 44 596. That is reflected in the last order passed by this court.
Also, the demand from the executive engineer is phase 49 lot. Phase 49 lordship will be. Present demand is lordship. Phase 49. Phase 49. 476.
You have paid some amount? No.
This amount was due, Lordship. I've not received this amount, Lordship.
You've got some amount.
Yes, I've got some amount,
But
but
after comma, petitioner was paid a certain portion of the work done. And the executive engineer, Udalguri Masbat Division within bracket irrigation, submitted a demand for fund to the chief engineer irrigation Assam on 7/8/2023, amounting to rupees 476.08698 lakhs, correct?
Correct.
Stop. However, comma, as the said amount has not been paid to the petitioner, the petitioner is before this court by way of the present writ petition. Stop. Of the present writ petition. Stop. Para. The you have filed affidavit on behalf of all the respondents.
Lordship, by the chief engineer has filed the affidavit. Lordship.
The chief engineer.
Lordship. Respond number 3, Lord.
Irrigation department.
Lordship.
The chief engineer, irrigation department. Oblique respondent number 3 has filed an affidavit. And in paragraphs 3 and 4, it is stated as under 8A, page 52. Stop. Considering the amendments made at para 3 and 4 of the affidavit filed by the chief engineer irrigation, comma, this writ petition is disposed of, directing the respondents to have a verification of the admitted amount, to have a verification and thereafter pay the admitted amount to the petitioner within a period of
minimum
4 months, Lordship.
5 months, within a period of 5 months from the date of receipt of a copy of the order of this court. With the above observations and the writ petitions.
Oblige,
Lordship.
32.
May I please? In this case, we have to file one rejoinder against the affidavit filed by a respondent number 5 Miller, 6 Miller.
Okay, Mr.
R. Sekar. 2 weeks time may be granted.
Learned counsel for the petitioner press for 2 weeks time to file rejoinder to the affidavit of opposition filed by the respondent number
6.
6.
May it please your lordship. Lordship, I'm appearing for respondent number 2 to 5, Assam Tourism. Lordship, actually the affidavit of opposition that is filed by the by respondent number 6, respondent number 6 to 8. So we also need to respond to this affidavit. So we would require actually 4 because there are a lot of documents that the respondent has been talking about. Those documents are very old documents, and I've already spoken to them. They are trying to procure the documents. So
you have for the respondent
2 to 5, Assam Tourism Development Corporation.
And who's respondent 6?
Respondent number 8 has filed the affidavit of opposition. 6.
Deputy Commissioner Bangaigaon. Is the Deputy Commissioner of Bangaigaon.
Okay,
So we require 4 weeks, minimum 4 weeks. Actually, lot of-
place for 2 weeks time. No, place for 2 weeks to file reply to the counter affidavit filed by the respond number 6, stop. MS
P. Burga, your lordship.
P. Barawa, Learned
Barawa.
Standing Counsel,
No, I'm a counsel for Assam Tourism,
Learned Counsel appearing on behalf of the
Assam, for
Assam
2
State,
to 5.
Assam State Tourism Department, appearing for respondents 2 to 5.
2 to 5.
Also placed for 4 weeks time to respond to the affidavit in opposition filed by the respondent number 6.
6, yes.
Praise allowed, please stop at 4 weeks.
Much of.
33.
My lord, the petitioner is a licensee of a fair price. Now, issue is, my lord, there are some allegations of wrongdoing. So his license was, my lord, suspended. Now, my only contention is, my lord, if your lordship kindly comes to page number para 30, one second, my lord. Yes, please come to para 14, my lord.
Of your writ petition?
Yes, yes. Sorry, para 13, page 17.
Ah.
Yes. My lord, that rule order 15 is quoted. Last 2 sentence. No order of cancellation shall be made under this clause unless licensee has been given reasonable opportunity of stating his case against the proposed cancellation by an order, but during the pendency or in contemplation of the proceedings of cancellation of the license. The license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case. So normally, my lord, if I am guilty of violating any conditions of the license, it is liable to be cancelled. Power has already also been given to suspend the license, but this suspension period would be outer limit of 90 days. It's something like, my lord, CRPC 167(2), my lord. Now, my only submission is, now you may proceed, whatever you may bring the action you want to take to is logical and I'm not there. But the suspension cannot continue beyond 90 days unless in the meantime, within 90 days, show cause is not given. Am I clear, my lord?
Yeah.
Kindly see, the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case. So it cannot exceed 90 days. Now, in this case, my lord, they in their affidavit, they say they had given us a charge sheet on 21/7, which is otherwise within 90 days. But my lord, our specific case is this show cause notice was never served upon us. That is why on the last occasion, my lord, government was directed to produce the records to show that the notice was in fact, that show cause notice was in fact served upon us within 90 days. That is how the matter is fixed today.
Hello. Original record has been seized by the police and we were asked to
This
produce the
case
photoscope.
we took up last time. I think I passed an order.
Yes, last occasion.
This court directed you, if you can't produce the original,
Yes.
go to the police, get the scanned copy or the
So we have
photocopy.
received from Deputy Commissioner the photostat copy of.
Whether there is any
Yes,
endorsement by which we acknowledge it, that's all.
Was. While 2 show cause 34.
No, subsequently one has been given beyond 90 days that we received, that even we annexed. But that 21/7 was never given to us. So if they have not given that 21/7, then my lord, it will attract the vice of 15(2). That subsequent notice we have annexed. No, you know. Why should we have received, my lord. On 27/11, notice was given that we received. But 21/7, they never given any notice.
Notice is issue that is there, my lord. But acknowledgement part.
Then The subsequent one we have received.
Because
it is photos that's.
No, even if it is photos, the endorsement would be there.
Has the petitioner received a copy? You have an interim order in your favor?
No, Miller. But there is an interim order, no? No coercive measure, no coercive measure.
So
No,
that
my lord.
your license is still suspended?
Yes. No matter, my lord, this has been, my license has been attached to another licensee who is catering to the needs, but then, my lord, people are suffering because they have to travel a lot of distance. My lord, it's an open and shut case, my lord. It's something like whether you have given charge sheet within 90 days. If you have given, then is otherwise what is entitled to default bill? Something like that. If I have received the show cause notice, there will be some endorsement.
Yes, Bakalia.
My lord, allow us some time so that we can collect from original records seized by the police.
From where did you get this record?
This is from additional deputy commissioner, original lying in the court probably.
Oh my lord. What has been produced is Xerox. Xerox is the original, but that even the Xerox does not, if original would have bear the signature of receipt, acknowledgement, then he also would have been
Okay,
there.
Bakalia, I'll give you one last chance. Next week, I'm disposing of this matter. Okay.
Well, next Thursday, my lord. Thursday. তুমি আনিব নোৱাৰা পুলিচৰ পৰা কেনেকে আনিব অসম্ভৱ কথা নেক্সট থাৰ্সডে
Please 1 week.
আজিৰ পৰা 1 week হ'ল
Today's
more than 1 week, more than 1 week, 8 days.
No.
It is more than 1 week. Today is Wednesday.
Okay. Heard Mr. Kian Chowdhury, Leonard Senior Counsel, assisted by Mr. A.K. Azad, Leonard Counsel petition. On request made by Mr. B. Bakalia.
G.
Bakalia, Leonard Governor Advocate. This matter on 27th.
Diploma.
To enable him to receive, to enable him to produce the reports.
My name may be recorded for Corporation Department.
Mr. Raj Goel, and standing counsel appears for the Corporation Department.
34.
It's time may be allowed to alert for filing affidavit on behalf of NHM.
On behalf of
National Health Mission.
NHM.
Yes, ma'am.
Your Lordship, by order dated 10/1/25, the Honorable Court has directed the respondent to file their affidavit, Your Honor. Till date, they have not filed their affidavit.
Details. Detailing instruction as that.
Okay, heard Mr.
P. Jha on behalf of B. Paul.
P. John and the counsel appearing on behalf of Mr. P. Paul and the counsel for the petition. MS.
A. Bora.
A. Bora, then it's standing counsel NHM. Praised for how much time?
2.
3 weeks time to file affidavit. To file affidavit. Stop. Praise the Lord. List after 3 weeks.
35.
That pleases your Lordship to pass over the matter for time being. Learned counsel Mr. A.R. Bhuya is on lake at another court.
After tomorrow, Lordship.
Yeah, after tomorrow, why?
Oh, otherwise I'm ready.
You file your affidavit?
No, Lordship, only instruction has to be required that whether the allegation is that after the due date, we have received some certain tenders. My instruction is to whatever has been received, that was received at the dispatch and receipt section. So that will be considered as a delayed submission.
Here it says, you may file your affidavit, that also is there.
May, Lordship.
May.
Well, Lordship,
May bring on record by filing affidavit. You want to file it or not?
Lordship.
Okay, heard Mr.
A.R. Bhuya.
A.R. Boya?
On behalf of
A.R. Bhuya.
Your good name.
Emily.
Emily, Leonard Counsel, appearing on behalf of Mr. A. Boyan, Leonard Counsel. Mr. P. Chakravarti, Leonard CDC submits that he has received instructions and prays for
2 weeks time.
2 weeks time to file affidavit.
Lordship interim may be continued, Lordship.
Praise the Lord.
Lordship may fix a date in that case, Lordship.
Release the matter.
Ninth or
9th April. Interim order procedure to continue till the next week. What is the interim?
Not to
Not to reject the claim of the petitioner.
not to process.
Authorized, Lordship.
36.
My lord, in this item 33, my lord, interim order probably not continued, my lord, please. Item 33, there was the interim order, but not continued. Sir.
Okay, interim order. I to continue till the next week.
May I please, Your Lordship? The electric connection of my house is disconnected.
Yes, Lordship, I prefer some time to file our response, my lord.
You got the instructions?
Yeah, instructor is, my lord, that there is a cap from electricity, my lord. So I need to bring that on record.
Got that,
Got
yes.
Mr.
Yes, Islamic.
Yes, Islam and the counsel for the petition.
B
Mr.
does, my lord.
P. Das, Leonard
B
Standing,
for ball, B does.
P. Das, Leonard Standing Counsel.
Yes, ma'am.
APTCL. Submits that he has received instructions and prays for
Hot date, my lord.
1 week.
Next week,
1
you'll
week.
fix a date on electricity
One
connection in my
minute.
house.
Let him file his affidavit.
Yes, my lord. 2 weeks, enough. 2 weeks.
Prays for 2 weeks then file it.
Fix a date, Your Lordship.
Okay, praise.
8 April.
My lord.
38.
Here we have sought for extension of the lease of the government fishery. Now, what has happened is, in the meantime, while this matter was pending, NIT has been published by the Deputy Commissioner. Now, we have put that particular NIT also under challenge, and that particular petition is coming up on Monday. So may I pray that this matter will be taken up on Monday, because the records are also with my learned friend.
On request made by Mr. P. Bharadwaj, Leonard Counsel for the petition.
There is an order from the division bench also. He knows it, Lordship. In the division bench, Lordship, it has been said that another party is opposed. And this matter is being settled, Lordship, that tender has to be opening on 28th of March.
28th is next Friday, my lord. I'm seeking for Monday.
Agitating before this forum, Lordship. I think it will be.
There should be a submission on that particular petition, my lord.
This petition will listed on Monday,
Monday.
24th. Because that case is also coming up on
Yes,
24th.
it will take both would take the same time.
My apprehension is that, Lordship, he knows this is agitating before this, Lordship. Already this has been decided by the division bench, Lordship, that tender has to be extended up to, we have to go for tender on 28th. Okay, then
Let it come, we'll see the division bench.
Public.
40. Orders.
Yeah, please, Lordship. My lord, this is the case where my fair price of license was cancelled. At the instance of MLA, my lord. Exactly, my lord, similar case, the other day, this honorable. High
File
Court-
your affidavit showing dusty service.
No, my lord, that perhaps Lordship may not be necessary, because same type of case has been already disposed of, asking the ADC to dispose of the appeal. Our case, our appeal is also pending before ADC. So Lordship may kindly pass a similar order. And otherwise, it is pending since 2021, and this is the source of my income. So exactly same case. That was also passed at the behest of MLA. This is also.
You filed your appeal?
Yes, that is page 16.
Page?
16.
Not appeal, my lord, application.
Application, but this common man do not understand that this is treated as appeal under order 25 of the AP Assam Public Distribution of Order. So exactly the same was the thing. So our prayer is this: let the ADC take up all the matters, and after hearing both the parties, necessary order may be passed.
Where is this order? 2/2/2021.
That order, page 20.
Hmm?
20, last two paras.
No, this is not 2/2/2021.
That by that order, my shop was taken to another person. This is the order I have been provided. So
No. 1 minute. In your application,
yes,
page 16,
yes,
paragraph 6,
yes,
you have stated that you have been issued a letter of 2/2/2021
yes,
for cancellation of your FPB shop. Where is this letter?
yes. That is there 6. Para 6 is there. So it was prayed kindly exonerate me from this cancellation order and reinstate my FPP
So where
shop.
is this order, 2/2/2021?
That order, my lord, is not with us. But my prayer is only limited, my lord.
Yes, what do you say?
The whole the matter be heard by the.
Man, it was before the additional deputy commissioner. It should be before the district commissioner. Man, he can file an appeal before the deputy commissioner. Man.
Definitely DC, but there are distribution of works among the ADCs. DC does not take all this matter. There are ADC supply, ADC education, etc. So
Let him
ADC,
file a matter proper appeal matter for the deputy commissioner, man, and that can be considered matter. The cancellation order is of 24 to 2021.
Where? Where's the
It's
cancellation order?
17.
Hmm?
Page 17.
constitutional order. Yes.
This was not Mr. M.U. Mahmood to learn concept. Also heard Mr.
Question number 1 to 5.
Mr.
M.
M. Chetia, learned government advocate. For the respondents,
1 to 5.
1 to 5. Para. The petitioner is aggrieved with the order dated
24 to 21.
24 to 2021. Passed by the superintendent, comma, food, comma, civil supplies and consumer office. Whereby is aggrieved by the order dated 24 to 2021. And 8 July, isn't it?
8 July.
No, already someone has been appointed in your place.
Yes, my lord.
No, it is.
It is a subsequent order, my lord, which was, my lord, his beneficiary has been taken with another person. my lord.
Another person, but he
Which part of the order?
yes, that is page 20.
Oh.
The B.
I wish. On a careful consideration of all the above documents and with the approval of authority by Sri Santosh Tati, son of so and so, appointed as new dealer temporarily. Vacancy arising due to cancellation of license of existing licensee Nondi Guala, license number so and so. He has been temporarily in the interest of consumers only given that time.
Okay, being aggrieved with the order dated 24 to 2021 and 8 July 2021, issued by the superintendent, food, civil supplies and consumer affairs, Silchar, by which the APTA, by which is it the APTA license?
Yes, ma'am.
Yes.
APTA license of the petitioner has been cancelled. And the same is sought to be given to the respondent number
6. ma'am.
Respondent number 6, comma. This petition has been preferred by the petitioner. Stop. Para. It is the case of the petitioner that he is the license holder of a fair price shop of a fair price shop under Uttar. You are the license holder of which shop?
It is shop. It's
Udarbandha Cooperative Society.
It is other one, that is the Shobha Samiti. That is the ration card. Padmavati Shower was found. Lordship may kindly see page 14, ma'am. Maybe ration cards of Basanti Panikar, ration card of Padmavati. Padmavati Shower.
Which one?
It will be the second one, actually. No,
You have not read the brief. On request made by MU Mahmood, learned counsel for the petitioner, released after 1 week. You come properly, please.
41, 42.
Let it, Lordship, may kindly fix it Friday. I will say this.
I'm saying 1 week.
May I please, your Lordship?
Yes.
Lordship, this is a case of restoration of electricity, my lords. My lords, in this case, my lords, I am the son, I am the petitioner, wherein I am the son of the
This is a contempt matter.
contempt along with writ petition, my lords.
Okay.
So basically, my lords, there was a direction given by the court. My lords, if my lords may take up the contempt application, my lords.
Yes.
There is an order.
Before my pen proceeds, my lord, as per last order, my lord, kindly, my lord, the last order that periods, my lord. There is a direction of this honorable court, my lord, to file affidavit regarding, my lord, the possession, my lord. The plea of the respondent father was that, my lord. The son, my lord, vacated the room of the father, my lord, 1.5 years back, my lord. And the son claimed that he is in possession. For this, my lord, an affidavit was required to be filed, my lord. But my lord, the father is a 72 years old person. He is suffering from illness for the last few days. He could not come to sign the affidavit. So I prayed for.
You're given 1 week time on that date.
Yes,
19 to 2025. What
Yes,
took
sir.
you so long?
We have prepared, my lord, but recently, my lord, he fell on ill, my lord, and could
Well, if I may submit.
1 week time, my lord, given, my lord, on next.
My lords, if I may submit, I'm so sorry, my lords. I seek apology for interjecting. My lords, the question here is this, the question of restoration of electricity. It is not a question of a landlord and a tenant. I am the son and he is the father. The respondent is the father, my lords. Now they want to bring an affidavit to say that I am not in the position, my lords. The law presumes that if I am the son, I have inherent right in the property. My lords, if they bring an affidavit saying tomorrow to the effect that I'm not in possession, let's say, and I'll bring an affidavit to the effect to say that I'm in possession. My lords, I put this question to myself, can a read court decide the question of possession and act as a civil court in disguise? That's the question that I put before myself. My lord, that affidavit will be redundant in itself, my lords.
Yes,
that is in my humble submission.
Submit, my lord, on 19/2, my lord, when this honorable court, my lord, directed to file the affidavit, my lord, on that day, my lord, the petitioner attempted to enter the room, my lord. And my lord,
don't go into all this.
Yes, my lord.
Don't go into all this.
FIR is lost, my lord. Police, my lord, came. Police came to the spot, my lord.
That is a different issue.
This is
Yes,
the
my
proof, my lord.
Concentrate on the contempt.
Yes, my
My
lord.
lord, contempt, I have submitted, I have, my lord, filed an IA, my lord, 501. Kindly, my lord, 501, my IA is, my lord.
My lords,
For
therefore,
vacating
if I may
the-
submit, my lord, as a
Vacating the
petitioner.
order, my lord. IA 501, my lord.
My lord,
Vacating the order.
There's no IF 501.
My lords, if I may argue my contempt application, my lords.
Hmm.
My lords, my lord has the contempt application.
Yes.
My lords, I want to take my lord's contempt application to para number
Where's the order passed by this court?
yes, my lords, at page number 18, my lords.
My lord, this order is, my lord.
If I may
for
be allowed to
vacating the
submit, my
order.
lord, for some time, my lords, without being interjected, I'm so sorry, my lords.
Page?
Page 18 of the contempt application, my lords.
Page 18.
Yes, my lords. Of the contempt.
Yes.
My lord has it.
Hmm.
It is by Honorable Justice Kalyan Rai Surana, my lords.
Hmm.
My lords, heard Mr. M. Sharma, learned counsel for the petitioner, as well as Mr. S.P. Sharma, learned standing counsel, issue notice of motion. My lords, I'll come to the last paragraph. Having regard to the nature of the dispute, where the petitioner stated to be operating his business establishment without electricity in his tenanted premises, the court is inclined to observe that the pendency of this writ petition shall not be a bar for respondent number 2, that is the, my lords, the APDCL, to exercise power under clause 4.52 of ARC code and to accept the prescribed load security and grant electricity energy supply to the petitioner. So what happens, my lords, that basically, my lords, I went for a vacation, then they disconnected my electricity. There are vague allegations that I did not pay the electricity, my lords. And thereafter I approach this court. Then thereafter what happens, my lords, that accordingly my APDCL took steps to restore the electricity at my place. However, my lord, that was being restrained by the respondent, and therefore the APDCL has actually filed an FIR in this case, my lords. If I may be allowed to produce, my lords.
My lord, before going to the contempt, my lord, I have filed an IA, my lord, for vacating the, my lord, order, my lord, in which he has filed the contempt, my lord. My IA is pending, my lord, for my lord, modification of the order, because, my lord, the order, my lord, it is mentioned that he is a business establishment, my lord. It is only, my lord, misleading this honorable court, my lord, the order is, my lord, obtained, my lord, for which I have filed the IA, my
That
lord.
I'll come to, my lords. All disclosure, I'll do it, my lords.
So my IA.
My lords, if I may read the FIR, my lords.
Yes.
Sir, with reference to the subject cited above in connection to the reference, I would like to inform that a temporary connection was applied in the office of Fatasil Electric Subdivision APTCL on 21/2023 by Sri Parvez Sahnawaz Ahmed, who is my lord the petitioner, for which an amount of 7150 has been deposited in the office. The service connection is sought by the applicant against the order passed by the Honorable Guwahati High Court. As such, a service meter with serial number so and so was installed in the premises on 21/2023, and the connection was given from the bus bar already installed in the same premises. But as per the complaint received from the applicant on 24/1/2023, the owner of the premises is not allowing the applicant to draw power from the allotted meter. On 24/1/2023, our team visited the premises and confirmed the applicant complaint. As such, we requested our kind intervention in the matter, my lords. My lords, that is the position. And my lords, I want to disclose it very fairly that there has been some error in the order that it's talked about business establishment. And to correct that order, we have already filed an interlocutory application, my lords. And as of it stands today, my lords, today I am being, my lords, my Article 21 of the Constitution is violated blatantly by the respondent because, my lords, they have restrained me. Now they are even restraining me from freely accessing my house and my property, my lords. If they have some problem, my lords, to restrain me from entering the house, their relief is in civil court, not in the writ court. And my lord, in my humble submission, this writ court will only decide on the question of whether the electricity should be restored to the petitioner or not, my lords. In my humble submission.
Yes.
My IA, my lord, 501. For vacating the order, my lord.
When was that IA filed?
My lord, IA filed, my lord, on 13/2/2023.
Now you want to press that IA?
Yes, my lord, because it is, my lord, for vacation of modification of this order, my lord.
After 2 years.
But this is pending, my lord. This is
pending.
Yes,
On
my
the first day, what happened? You were not present. That's why it was adjourned.
Well,
And it was never moved.
They have, my lord, replied, my lord. They have filed a reply, my lord.
Come to IA
501, my lord. 501, they have filed a reply.
Come to IA 501.
Dealing tactics.
Yes, my lord. They have replied, my lord. 501.
Any notice was issued?
Yes, my lord. They have replied, my lord. Filed a reply.
Any notice was issued in 501?
Yes, my lord. They were present.
You show him this order.
They filed their reply, my lord.
File has been replied, but chicken.
Reply is on record, my lord. Their reply.
What is this? 419 is yours.
Yes, my lords.
What is this for?
My lords, in IA 419, my lords.
That is correction.
Rectification of the order, my lord. That business establishment was written, my lords. That we have fairly disclosed to the court that there might be some discrepancy. Therefore, we want to rectify that order, my lords. And that's a fair disclosure which has been raised by my respondent today itself also, my lords. And my lords, these frivolous submissions have restrained me from enjoying the property which I'm entitled to, my lords.
My lord, for disposal of this matter, my lord, some time will be required, my lord. Because
my lord, restore my electricity till that time, my lords.
But why are you stopping?
Yes, my lords.
My lord, he is not in the premise, my lord, for last one and a half year, my lord.
Whether the petitioner is there in the premise or not, there's a court order giving direction to give temporary connection to one particular meter.
No.
When the APTCL went to give connection to that particular meter, you stopped the
My lord,
officials of the APTCL.
I humbly submit.
Why are you interfering with the court's order?
My lord, I humbly submit that, my lord. There is no direction for my lord for connection, my lord.
Have you read the FIR filed by the APTCL?
No, my lord.
This is an independent body.
My lord, the order, as per order of this honorable court, my lord. May I read the honorable court's order, my lord? There is no direction for, my lord, restoring the connection, my lord.
Just read the APTCL FIR. Have you given him a copy?
APTCL FIR is there, my lord, but my lord,
he admits
court's direction is not there, my lord, for restoring the installation, my lord.
Where's the court's direction? Do
My
I
lord,
have to find the content?
Page number 18, my lord.
Yes. Read.
Page number 18, my lord.
Ma'am, his plea in my lord, in a reply to your affidavit, my lord, is that you provide a separate connection. We don't have any problem. I don't understand, my lord, what is the problem? It is coming from the bus bar. We can make a disclosure before the court. Any payment will undertake that will make the payment.
18, my lord. Having regard to the nature of the dispute, where the petitioner stated to be operating his business establishment, this is a misleading statement. Behold,
Correct.
yes.
Not
And
a
my next
misleading statement, but according to the petitioner in the IA 419,
Yes, my lord.
they said that this was wrongly recorded, so they filed an application
Obliged.
for correction of this particular line.
Obliged, my lord.
Okay, with further on.
Next, my lord. Without electricity, his tenanted premise. This is also wrong, my lord. His son.
Carry on.
My premise is living. This court is inclined to observe that pendency of the writ petition shall not be a bar for respondent number 2 to exercise power under so and so code and to accept the prescribed load, security, and grant electricity energy supply to the petitioner. My lord, for the time being.
So when they went to give the electric connection,
yes,
you stopped them.
My lord.
You stopped the APTCL.
My lord, as per 452. Now, my lord, let me go to the 452, my lord.
I'm not going into that 452. I'm on contempt. Why have you stopped the APTCL from giving the power connection?
My lord, this honorable court, my lord, directed as per 452, rule 452, my lord. They did not follow 452, my lord. The 452 is in their my lord petition. 452 is not followed, my lord. What is 452, my lord? 452.
Whatever it is, you could have come before this court to say that under so and so, they have done wrong. But you could not have stopped them.
My lord,
they were executing this court's order.
No, my lord, not executing. My lord, 452 is that, my lord, that
You're not executing.
My lord.
Okay.
My lord, what my humbly submit, my lord.
No.
My lord, for a moment, my lord, my submission may be recorded, my lord, that yes, this honorable court's order is that to follow the 452 rule, my lord.
Who's the contemptor?
My lord, 452 rule is the, my lord.
I filed the contempt
I may
petition,
be allowed to submit, my lord.
Opposite party.
My lord, I may be allowed to submit, my lord, for a moment, my lord.
Let him appear in person. Yes. Gyasuddin.
He will definitely appear, my lord.
Let him appear in person.
Yes, he will appear, my lord. And my submission may be, my lord.
You're making your client's case worse. If you open your mouth again.
My lord, if I am not allowed to submit for my
because
client,
I've read all the orders passed by this court. I've read the FIR filed by the APDCL authorities.
But my lord, 452, my lord, dishonorable court not read, my lord.
That I'm not going into that.
The court
that
order,
I'm not going into.
Court's order reflects that, my lord, 452.
Court has passed an order. They've gone to execute that order. You stopped them. You could have come to court and said by way of filing an appropriate application saying that no, under 45 so and so, they should have done like this, but they have done this.
Yes, well, they did not follow
that. You did not know. Instead, you tried to obstruct them.
My lord, since I did not follow, my lord, 452, my lord, this is my humble submission, my lord. And it is on record, my lord. 452 is on record, my lord. 452, my lord, states that, my lord, the owner's no objection is required, my lord. Owner, I am the owner, my lord. Owner's no objection is required, my lord, for this, my lord, connection, my lord.
My lord,
and they did not obtain my objection. No
have been
objection, my
taken
lord.
by APDCL, my lords. That APDCL does not take any objection at all, my lord. If any statutory guidelines has not been taken, then APDCL are taken forward. My lord, now the statutory, how the statutory guideline would be, my lord, interpreted is not upon the respondent to decide, my lords. All that I'm asking, my lords, that my Article 21 violation, my lords, I am the son, I'm entitled to the property.
How entitled, my lord? Till the survival of the parents, my lord. He is torturing the parents, my lord, for the last 7 years.
All vague allegations, my lords.
My lord,
no vague allegations.
I'm not into whether the father is torturing the son, whether the son is torturing the father. That is not the concern of this court.
This is on record, my lord.
All right.
My lord, on several 10 to 12 cases are, my lord, he filed, my lord, against the father and mother, my lord, old age at 70 years old father and 70 years old mother, my lord. He has dragged him to Lakhimpur, my lord, by filing a domestic violence case by his wife, my lord. This honorable court interfered and transferred this matter, my lord, Guwahati, my lord. Because, my lord, by falsely stating that she is the resident of Lakhimpur, my lord, this honorable court will I have annexed all the orders, my lord. And more than 10 cases are pending, my lord, against his, my lord, old age parents, my lord. And my lord, I have, my lord, annexed photographs, my lord, where he physically tortures, my lord.
My lord, his case as per records.
Yes, proceed. Proceed.
Yes, my lord. So, my lord, from the year 2017, my lord, this son, my lord, the younger son of the petitioner, has been, my lord, physically and torturing the parents, my lord. And they are, my lord, they are ready to leave the place, my lord, only for his torture, my lord. At any time, they may leave, my lord, the property, my lord, this case, my lord. All the annexure is there, my lord, the pending cases, my lord. I have also annexed the photographs, my lord, where the sustained injuries, the old aged, my lord, father, my lord. In several locations, he had, my lord.
This court appreciates what you have said.
Yes.
All right.
Yes.
But the only thing is this contempt case
Yes,
is for giving electricity connection,
yes, my lord.
correct?
Yes.
After that, you do what you have to do.
But my lord, the electricity department, my lord, as per.
And in the last occasion, you were given a week's time to file affidavit.
Yes, my lord.
You have not filed your affidavit till now.
My lord, because my lord, he has been, my lord, he had attempted to, my lord, enter the room, my lord, after 1.5 years, my lord. And there was a, my lord, assault, physical assault, my lord. He has sustained injuries, my lord, the petitioner and his, my lord, elder brother, my lord. All is on record, my lord. FIR has lost, my lord, both parties. He also lost FIR. My lord. So
Okay,
one
you
week-
file your affidavit then.
I prayed
My
one
lords,
week time,
I'm
only
so,
1 week.
I'm so
time.
sorry, my lords. My
One
lords,
week
these are
time, my lord,
always, my
prayed,
lords,
my
I'm so sorry. My lords, I want to make one humble submission, my lords. This case has been revolving about only one submission of my learned colleague, is that there are some fight going on in some other court. My lords, the question here that the read court, my lords, for is this whether the electricity connection should be restored or not. My lords, they have tried to beat us. My lords, we have filed an FIR.
Heard, Mr.
Amberman, my lords.
Learned counsel for the petition. On request made by Mr. M. G. Kati, learned counsel for the sole respondent. You are the sole respondent, isn't it?
Yeah, respondent number 3, my lord.
No,
I am
sole
3, my lord.
respondent, I think.
Contempt, my lord. I am sole respondent.
Sole respondent.
Yes.
Indeed.
Lord,
It's in the contempt.
Well, if I may ask for just one relief, I'm so sorry, my lords. I'm seeking apology, my lords. Only one relief I'm asking for today is, my lords, that the status quo as of on the date of filing of application be maintained, my lords.
1 week time to file affidavit, no? List on. Please what? 20,
On Wednesday, my lord.
okay. We'll have it on first April.
Okay. My lords, with regards to status quo of my lords, because he may destroy my property, my lords.
My lord, where it is his
My lords,
property
only
and my
status,
property. my
I'm
lord.
asking a very limited.
In the main writ petition, you have all filed your affidavits?
Yes, my lords. My lord, only one thing I'm asking.
This matter on first.
My lords, status quo, my lords. As
What status quo?
status quo as on the because he does not, so that he does not destroy my property and everything, my lords, which is there in the house.
My lord,
The
my
risk-
property, my
Your
lord.
father is the old man.
I am the father, my lord.
My lord, that's the. I'm so obliged, my lords.
43.
Yes, Chalia.
Yes, Lordship, here the contempt relate to payment of bills, Lordship, to the petitioner, Lordship. Financial concurrence has been given as per our instructions, Lordship. By Learned senior friend, Mr. who's appearing for the animal and husbandry, Lordship can make a specific clarify when the payment can be made.
Bhagwati?
I have got the information just now, Lordship. I will take a week's time.
Okay. Heard, MS?
Lordship, lack of fund and obtaining instruction always cannot be used in.
No, they've given the concurrence. Final has given the concurrence. You wait, you'll get the instructions, you'll get your money. Heard, MS?
And thus.
Learned counsel for the petition. Mr. A. Chalia, Learned, standing counsel, no, is a contempt case.
Yes, Lordship.
Learned counsel appearing for the
Respondent
respondent number 4 submits that the finance department has given the concurrence for financial sanction. And no, let's say, that by communication dated 4th March 2025, the Undersecretary to the Government of Assam, Finance within bracket EC-1 department has given concurrence for financial sanction to clear the liabilities of the petitioner. Stop. They say by communication, there is an address to the Undersecretary to the government. No, an address to the, no, okay. Mr. M. Bhagwati, Learned standing counsel.
For not standing counsel, respondent one in the contempt matter.
Okay, Learned counsel appearing for the respond number 1 and 2, price for a week's time to enable him to receive instructions.
Lordship, a copy may be furnished to us.
Praise allowed. List on 1st April?
Not.
You finish a copy?
Yes,
if
Lord.
you have.
Not.
44,
Contempt order is at page 64, my lord. And
Notice is served.
64 is the
No, no.
order, and 67, page number
No,
67 is
please.
the 14%. Para 8.
Respondent 1, 2, and 3. Where the notice has come back. You have 4?
I am for number 4.
4.
For 5.
You have for 5. 4 and 5. How about 6? No.
No. Very my lord.
AD card has come back in respect of respondent 6. Chitia is gone.
So,
Chalia, just see if Chitia is there. Water resources.
Water resource, lordship, response number 1, 2, 3 is not served yet, your lordship. I am appearing for 4.
4. When was notice served? Sent 38. You want to take first steps? Okay. MS R Deca, Learned Council. Enters appearance on behalf of respondent number
4, your lordship.
4. And MS PR Mohanta, Learned
Sending
Council.
of-
Learned Council appears for the respondent number 5. Correct. Stop. Para. Learned Council for the petitioner praise for taking first steps for service of notice on the respondents 1 and 3, 1, 2, and 3 by registered post AD within 1 week.
alright.
Praise allowed. Let such steps be taken and completed within the period of 1 week. List after 4 weeks.
Alright.
45,
My lord, last time, my lord, for my lord, opposite party number 1 to appear.
R Devi was the
Yes, lordship, today she could not come due to some personal difficulty. Otherwise also she has not received the instruction as told by her lordship. So 2 weeks time may be granted so that.
Last time, your lordship has asked for instruction.
But she has
She is not well.
Third, Mr. NNB
One
Chowdhury,
one week,
Council for
at all,
petition.
lord.
On request on behalf of MSR Devi, Learned Council appearing for the respondent 1 and 2. List after 2 weeks.
Can we do 1 week, my lord?
She's not well yet.
Yes, sir.
Get well proper.
Lordship, she could not, because she is not unwell, but because of some personal difficulty.
46,
Meet with the lordship. 46 and 47, my lord, then are contempt cases, and Mr. Kolita is already appearing, and he took time last occasion to
Lordship, the SLC,
instruction.
SLC happened, and whatever the eligible amount that has been approved. So now only thing is that lordship, like after the SLC, this goes to the central government for pre-audit. So it has gone for pre-audit lordship, so it will be done maybe, they're seeking for 2 months time lordship. I have that SLC minus.
High Court
Something is
order.
happening.
High Court order. So. Look at the video. I may be also finding second.
According to you, what is that? The SLC has?
So SLC, lordship may kindly come to the last page, that is at page 8. So the last line, lordship, after trade bureau discussion committee approved such and such amount, additional amount, and approved so and so amount. So this amount has been approved, lordship. So only thing is that like the central DPIPT does a pre-audit. So it has been sent for pre-audit. Once pre-audit happens, then the money will be released by the nodal agency, that is Netfee. So they are seeking some time, 2 months time they are seeking.
Okay.
Who is digging?
But MSN Sakia Learned Council for the petition.
Don't think so.
Mr. A. Kalita Learned Council appearing on behalf of respondent 1 and 2 submits that the state level committee in its meeting held on 6 July 2024 had approved rupees 11,35,371 as additional eligible investment in plant and machinery, and also approved 30% of the CCIS.
And approved, let's say, out of 11 lakhs, so 30% will be 3 lakhs.
No. And approved 30% of the CCIS as rupees 3,40,611. He further submits that the matter has now been forwarded to the
central government for pre-audit.
To the central government for pre-audit. And accordingly,
After the pre-audit, the amount will be
placed for 2 months is difficult. to give.
Yes.
Actually, let's say,
Let it be after after
yesterday,
vacation
I
maybe.
spoke to our officer, they have spoken to the central government official there. They are saying like to at least give us 2 months time. That's what I'm submitting.
That's what I'm, some of the, within 10 days, they have asked to release them.
Place for 2 months time.
2 months time,
Receive
you
for
rest 2
updated
months.
instructions.
If
Let
the
us
court
keep-
order is
let-
there
let us
after
keep-
vacation, my lord? 3 weeks time may be given.
No, 3 weeks will be, no, it will not happen, let's say, because they have sought for that.
No court order, they
I'm
cannot
submitting
deny.
on
na.
instruction.
They cannot.
However,
Uh,
this court is not inclined to grant 2 weeks, 2 months to the
Time.
respondents. Accordingly, list the matter on, I'll give 1 month. After that, we'll see what happens.
Yes, ma'am.
1.5 months, lots of may do, 45 days, 45 days.
1 month. ठीक है, sir.
45 days.
2 days.
List
19.
the matter on 30 April. That's
30
45
April.
days. 30
I have
April.
some marriage, my lord.
Huh?
Nephew's marriage, little bit earlier, man, 27, 26.
Or after
In the
that,
first week of May, Lord, the first week of May.
26, man.
First week of May.
April on 5th May.
5th.
Is it okay?
Yeah. Next also, I'll send.
Next one, Lordship, also Lordship, that's reconsideration happened and subcommittee has recommended the amount. So this will be placed before the SLC. So whenever the next SLC happens, they will.
Heart
place
and Sakia Learned Council for the petition. Mr. A. Kalita Learned Council appearing for the respondent 1 and 2 submits that the subcommittee
Fulfill the demand. Whatever.
in its meeting held on 30 January 2025 have reconsidered the case of the-
Reconsider the matter and they have approved the amount.
and
They have
the-
approved,
they have approved the amount
amount is coming to 11,74,000 or 24.
amounting to rupees 11,74,424. He submits that the matter would now be placed
Next
before the state
SLC, whatever
level,
next
before
SLC.
the next immediate state level committee. And accordingly placed for 2 months, 2 weeks time,
1 week, 1 month time, same like same.
placed for 1 month's time to enable him to receive further updated instructions. Praise the Lord. List on today's 19. When is your marriage?
5th
30
May.
30 April, my lord. 30 April,
Okay,
5th May, Lordship, same day.
25,
Okay.
26.
okay, 5th May,
5th,
same day, let
same
it come up.
same day.
Okay, ma'am.
48.
Obliged.
My lord, Lordship, in this case, my lord, fix the matter, my lord, on 28, my lord, next Friday, my lord.
No,
My lord,
no,
senior
no,
council
27.
already discussed, my lord, 27, my lord.
My lord, My lord, this IA has been filed for vacating an interim order. And if your lordship takes up the record, and there is a specific order by your lordship on 27/1/25, where there was a direction for listing this matter in the admission column. But repeatedly, the matter is getting listed in the orders for which it is coming at the bottom of the list. Lordship may have a look at the order passed on 27/1. So since the entire matter needs to be heard, and perhaps the time is also not available and Mr. Chaudhary, senior counsel, is appearing. So let the matter be taken up on 27 and there be a direction that should be listed in the admission column so that it comes up higher in the list.
This
Instead-
is,
A stay vacating application.
Stay vacating application.
Stay vacating application, and your lordship has expressed that your lordship will be taking up the entire matter for disposal.
Okay.
If your lordship takes up that order of 27-1.
Okay, heard Mr. S. Chakravarti, learned counsel for the applicant. As well as Mr. Ellen Dihanke, learned counsel for the opposite party number 1.
Lordship.
Public writ petitioner.
Lordship.
For the, don't say opposite party number 1, don't say opposite party public writ petition. Stop. Huh? List the matter on 28th.
27th, my lord, is a hearing day.
27th in the
Admission.
What do you call that orders, what is usual? Stay vacating column, huh? Just, you just write it. Yeah.
27th.
My lord, there was an interim order, my lord, interim.
Interim order passing the main writ petition to continue till the next week.
Master plan.
49.
Lordship, here in this case, order dated, my lordship dated 24/1/2025. Out of the contextual works, I have received the 1 crore rupees. The matter may be disposed with the direction to verify the matter by the respondent authority. Other parts.
Lordship, total services have been completed upon the response number 224, Lordship, but they haven't appeared, Lordship. I am only appearing for response number 1, your Lordship.
In the who is 224?
It's a
Bridge and roof company here. Government undertaking.
the government of India undertaking, Lordship, but it's a company, your Lordship. It's a limited company.
Otherwise, I have received all the payment, your lordship, during the pendency of this writ petition.
So if they've paid all the amount?
No, little, 1 crore has been paid out of 3 crores 12. The remaining will be disbursed by them. It is in the office here. After verification of the records, I'm filing my writ petition.
But without hearing them, Lordship.
So it has been there on record.
When was notice? When was notice?
Notice has been served on your lordship.
I think the office not reflects, your Lordship.
We have already taken the steps repeatedly, your lordship. And this honorable court has directed to file an additional affidavit also.
Taken, Lordship, in the month of January, your Lordship.
So long pending, my whole.
So the matter is of like September 2000.
Even I have also, your lordship, submitted the penalty of the GST tax.
Notice is served. 2, 3, and 4.
Yes, lordship, they have not responded. So
let us wait for under 2 years, Lordship.
No,
Because
wait for
it's
2
an
weeks
enterprise
time.
under Calcutta, your Lordship.
No, the office at Kistan Basti, your lordship, here itself. 1 week.
Maybe,
your
maybe.
lordship.
Lordship, but
Dr.
I'm
P.
not aware of.
Gogoi, learned counsel for the petition. Stop.
As a last chance, your lordship.
Peruse the office note dated 7/3/2025. Oh, no, don't say like. Peruse the proceedings of the Lawazima court. Dated 7/3/2025. The notice on respondents 2, 3, and 4 shall be deemed to be complete. Stop. None appears for the respondents 2, 3, and 4. However, in the interest of justice, list this matter after, okay, 2 weeks. On
Date
that
may be
day,
fixed.
on that day, will
The date may be fixed, otherwise it is very difficult to catch.
date after 2 weeks.
7.
7th of April.
Deeply.
50.
Deeply.
50.
None appears for the petitioner. Mr. K. Gogoi, Leonard, what additions? Senior government advocate appears on behalf of
Respondent number 1 and 2, Lordship. 1, 2, 3.
Hailakandi,
5.
Municipal Board.
Not more, Lordship. In this case, Lordship, we have obtained instruction, Lordship. Otherwise, they have to approach the civil court, Lordship. 2 wives claiming for Lordship, legal heir certificate, Lordship. That's why the municipal were unable to issue the certificate, Lordship. That is the reason, Lordship.
Okay. Mr. K. Google and additional senior government advocate appears for the respond number 2. List after 2 weeks. Let us see. Maybe they've gone, that's why they're not.
Lordship, Lordship, Lordship.
51.
Lordship, in this case, the missing autonomous council is supposed to file their affidavit. Matter released to the supply of.
Notice has gone.
Notice is gone.
Notice gone, my lord. There is an official matter, a wrong update.
Who is respondent for?
This is the beneficiary of that tender process, Lordship.
So, my lord, our affidavit is ready, my lord. We are sent for betting.
Last time also same was.
No, my lord.
Same submission was made.
Last occasion, Lordship, my lord, instruction was received, Lordship.
Respondent for has to be heard.
Yes, Lord.
Yes, Lordship. No, here, interesting fact is that, Lordship, the tender, all hold or tender, Lordship will find to page 54. It was uploaded on 6th of January. And they want to say that by November, everything has been completed, work order has been issued.
Whatever
payments
it
also-
is,
That's why the.
according to the postal remark, no such person in the address.
Let my friend submit, furnish the address. They have issued the work order. By tomorrow, I will take step by tomorrow itself. First step.
Can you take steps?
I will take steps.
No, no,
Yes,
Lordship, I have to take instruction.
he has issued the work order. For that, he something fishy going on, Lordship.
Okay, heard Mr. B. Chakravarti and the council. Stop. Peruse the office note dated 19/3/2025. Stop. Mr. D. Gogoi. Learned counsel appearing for the
Respondent 1 and 2, Lordship.
respondent number 1 and 2 shall furnish the correct and proper address of the respondent number 4 to the learned counsel appearing for the petitioner. Within
2 days.
I bless my lord to get instruction, Lordship.
What instruction for the address is to
No,
take?
no, this is in the office, Lordship.
So you get the address.
Yes,
for
Lordship.
He need not need to go there. He can talk, take it over telephone.
Within 1 week from today, stop. After comma, the petitioner shall take first steps on the correct and proper address of the respondent number 4 by registered post AD within 1 week. Within 1 week. Draft list after
4 weeks, Lordship.
4 weeks.
Lordship, can it be on 21st or 23rd of April?
List on 23rd April.
Lordship.
Hello. 52.
Right, please, Lordship. Lordship, an interlocutory application was filed for impleading respondent number 8, 9, and 10 of this present IA Lordship as party respondent, Lordship. And
Who are the 8, 9, and 10?
yes, Lordship, and it was also directed to make necessary correction in the cost title, Lordship. But due to bona fide mistake, Lordship, at that time, that correction was not done, Lordship. Later on,
One minute, 1 minute. Which IA? 699.
Yes, Lordship. By order dated, Lordship. Page 12, Lordship, kindly see, Lordship.
1 minute.
Page 13, Lordship.
In the IA? There's no order in the IA.
Lordship, kindly see page number 13,
Just
Lordship.
let me have a look here. IA 149. Oh, this is a new IA. IA 149.
It is a disposal of this IA too. That IA has been disposed of, Lordship. Kindly see page number 13, Lordship, of the present IA, Lordship.
149 is disposed of,
Yes, yes,
permitting you to implead one giant Narlika.
No, not Lordship. That IA was filed later on, Lordship. Earlier, one IA was filed, Lordship, to implead respondent number 8, 9, and 10, Lordship.
In that 149?
Yes, Lordship. No. that I have been disposed of, Lordship. Number I could not collect, Lordship. Kindly see page number 12, Lordship. Kindly see.
Page number 12 of
12,
what?
12. Present IA, Lordship.
Present IA,
Yes, Lordship.
699.
Yes, Lordship. Present
Okay,
IA, Lordship.
okay, okay.
Page number 13. Kindly see, Lordship.
Huh?
Since there is no representation on behalf of the petition, let the registry issue notice to the newly implemented respondents, number 7, Povitra Ram Khan, Samir Sinha, and KM Gopal Rana, and also to do necessary correction in the cost title.
Hmm.
This correction was not done, Lordship. This correction was not done in the cost title, Lordship. Later on, again, one I was filed to implead respondent number 11, Lordship, Jan Narlikar, Lordship.
Hmm.
But if the correction was not done in the earlier IA, Lordship, in this order, Lordship, Jan Narlikar appears as respondent number 8, Lordship. Instead of respondent number 11, it ought to have been, Lordship, as respondent number 11, Lordship.
1 minute. Hmm? Five three one 2015. 3373 2023. One minute. 149.
149 was for Jan Narlikar, Lordship.
Oh.
Yes. Earlier, another application was filed 3378.
Lordship may check the last order, Lordship. It's Lordship's order only. Lordship had directed Mr. Jayan Narlikar to be pleaded as respondent number 8. As
No,
per
that's
the-
why, that's why.
Uh,
In the, in
But
your,
Jan,
in your IA,
yes,
which was 149 of 2025,
yes,
you have prayed for impleadment of Jayan Narlikar IAS
yes,
as party respondent number 8.
yes.
Okay,
It was a mistake, Lordship.
it was your mistake.
Yes, Lordship, my mistake, Lordship.
No, okay, 1 minute.
It should have been Lordship, respondent number 11, Lordship.
So how do we correct now?
Necessary correction, it may, my lord may be allowed to make necessary correction in the cost title so that I can implead all the respondents serially, Lordship. 8, 9, and 10 left, Lordship, in between, Lordship.
Big confusion.
Lordship, but we have already granted concurrence to the proposal. Lordship may grant them some time to make the necessary. In the meantime, maybe we can comply with the court's order only, Lordship.
Okay.
Yes, because we have already given our concurrence. We'll just.
No, the only problem is that in that IA 149,
Yes.
we have directed the Jayan Narlikar should be completed item number,
Respondent number 8.
respond number 8.
Yeah,
All right.
yes.
And in that IA of 3373,
Yes, in that IA, Lordship, respondent number 8, 9, and 10 were allowed to implead, Lordship. And it was also directed to make necessary correction in the cost title, Lordship. But due to our mistake, Lordship, the necessary correction was not done, Lordship, in the cost title. That is why Jayan Narlikar appears as respondent number 8, Lordship, instead of respondent number 11, Lordship.
now from where does 11 come?
Because if we had made the correction, Lordship,
Those three
those
persons.
were included.
So those were 7, 8, and 9.
There were 7, Lordship.
8,
If-
9, and 10, Lordship.
If those 3 were included, Lordship, then it would have been 8, 9, and 10, Lordship. Then Jayan Narlikar would have come at 11, Lordship.
Okay.
That is.
Then what is this IA now?
This is I have to make necessary correction in the cost title, Lordship.
Implead Jayan Narlikar
Yes,
is 11.
yes.
Lordship.
No, yes. I can't understand what you're stating in this. I use. If I pass any orders, there will be total confusion in the registry.
Also because as per this application, she wants to implement Janalika 8, that is not possible if.
Already implemented.
Yes.
Now the registry will be
8, 9 and 11, 40%. No, 8, 9 and 8, 9, 10 and 11 may be allowed to input in the cost title, Lordship. It may be allowed, Lordship.
see, all these are all judicial orders. All right,
Yes,
correct.
yes,
In 149, this court directed Nalika to be implemented as response number 8.
yes,
And you were directed to file an amended cost title.
yes, yes.
You did not do that.
No, Lordship.
You,
I
because
went to
you,
do that then at that.
because you could not do it because in the earlier IA,
Yes, yes.
these 3 persons, they were asked to be implemented as, there also something is wrong.
8, 9, 10 is.
There it is said 7, 8 and 9.
No, Lordship. 7 is, it is handwritten, Lordship.
Okay, whatever it is, 8,
Yes.
9 and 10.
Yes, Lordship.
All right.
Yes.
That is also a judicial order.
Yes. It could not be complete, Lordship.
Now all these judicial orders will have to be corrected. Only then after that we will have to what is the way out? Just stop the live streaming.
Notice, notice